So now think about a firm which has borrowed from both of these lenders. One is a relationship lender, and another is a transaction lender. And the firm has only enough to repay one of those two lenders. So which one would the firm prefer? And that is the base question I'm trying to answer here. The institutional setting you mostly are aware of, but I think two things that I'll need for some of my tests here is, one is that debt recovery tribunals are known to increase help the recovery process, and there was a regulatory forbearance between 2008 and 2015 where banks could restructure loans without without putting up additional risk capital, so they could restructure as much as they wanted without suffering the cost for it. And then there was an asset quality review that happened around 2015 and 2015-16 and continued thereafter, which led to some decline in lending in the overall economy. Now, the basic question you understand, right, that it's a simple question. A firm has only enough to repay one of the two lenders. Which one would it prioritize? One lender has more information about you. The other one you have some transactional relationship with. And so the kind of data I'm looking at is secured loans data from Ministry of Corporate Affairs website of Index of Charges. You collect all those. You enter each firm's company identification number. You get a list of loans. What is the loan amount, what is the address of the lending branch, has the loan been repaid, what else, the starting of the loan, if it was modified or not. And then I map it onto the TransUnion CIBIL default data. So that matching takes some effort because you have to match by names. TransUnion CIBIL's website, this one, you can find all suit file cases against each firm. The only condition is that the default has to be larger than 1 crore. But these loans are fairly large, so I don't worry about it as much. Every quarter, you get a new file on their website where you will get a list of all large defaulters, and you can map it on to using the firm name back onto the MCA's index of charges. What you end up getting is, what I ended up getting was 25,000 firms who have borrowed from 380 lenders between 2003 and 19. Why 2003 as a starting point? Because the default data starts in 2003. And these loans are distributed all over the country. I want to bring your attention to three things here. One is the number of lenders per firm per year. That is, on average, how many lenders is a firm borrowing from, which is pretty large here. It's 6. And 2/3, then the number of listed firms. The proportion of listed firm is only 1/3. So I'm looking at this large set of firms which are not listed in the market, so you cannot impute information about them using financial markets, the stock markets, or their disclosure norms are somewhat lower compared to, or more relaxed compared to the listed firms. So that's where relationship banking also becomes somewhat more important in that scenario. And I also want to bring your attention towards this default number of 0.0195, which is, think about it as 2% default. That is the overall default that I get in this data. I understand there could be some matching error, but as long as they are not systematically inclined towards one of these two kinds of banks, I don't worry about it as much. Now, this is the most contentious part of the paper, that many people won't trust my measure of relationship, including professor here. They have a lot of questions about relationships measure. Because I understand it's an intangible thing, right? It's an abstract thing, relationship, how do you measure it? So I very heavily rely on the literature, and to an extent I believe that this measure does capture relationship or the information content between the firm and a bank. And so there are three measures that I combine. One is physical proximity, how close is the firm headquarters to the lending branch. The idea there is that it is easier for the branch to monitor that firm or actually visit the CEO of the firm or see how the operations are going or any other details that you cannot see in the financial statements. So there is easier collection of information and also easier monitoring. The second is the number of loans or the frequency of interaction. The assumption here is that every time a firm and a bank the bank makes a new loan to the firm, the bank updates its information about the firm. So ideally, you want to capture every time the firm and the bank meet, but this is a proxy for that, the number of loans they make. And then there is a depth of relationship that is measured by the loan quantum, how big the loan is. So the more that, and that goes the other way, the assumption is that more the bank knows about the firm, the more it will lend. And I combine it in such a way that if a lender, for a firm, for each firm I define a relationship, whether they have a relationship or not. And if a bank is above median all these three relationship strengths, then I'll classify it as a relationship lender. What it means is, think about a firm in Bangalore which borrows from two banks, one in Chennai and one in Hyderabad, let's say. And so Chennai is, let's say, closer. So the distance measure will give you the Chennai bank as the relationship bank. And then you look at the number of loans made and the quantum of loans made. So also the closer bank and the bank which lends more in both in terms of number of loans and the quantum of loans and has lent more recently. I also incorporated that using this time measure here, that I weigh my number of loans and quantum loans by time, so, and then add them up. So the more recent loans have higher weight. So for a firm, the relationship lender is the lender which is closer and which lends more often and which lends larger amount and has lent recently. That gives you, this is just a validation of whether this works. I mean, as mechanical as it could be, that relationship lenders are closer and they lend more, both in terms of numbers and quantity. So if you just look at the firms which actually have these kinds of relationships defined by this measure and look at just their default numbers over the years, you see that relationship banks have faced more default just by looking at the plain average numbers. And then you can also look at their t-tests but we can, what I want to do is, I want to regress just, and in academic word, we call this, of course, like the identification that you have, the causal identification. So my data is at firm, bank, year level, and that is matched with default. There's a default dummy. And then I put in a firm cross time fixed defects. What that does is, it absorbs all your firm time varying and invariant characteristics. What it leaves you with is within firm, within time, across lender variation. And then because the decision to repay or allocate its funds to which bank comes, it's the firm's decision itself. So once you absorb firm cross time fixed defects, what you're left with is the firm's choice to delay payments towards one kind of banks or the other, depending on their relationship. So I'm just regressing default on relationship, but the more important part is the firm cross time fixed defects and the lender fixed defects. Lender fixed defects absorbs your lender level characteristics, like is it a public sector bank, is it a low capitalized bank, large capitalized, well capitalized, all those things. And across several metrics, willful default, non-willful default, loan amount, or whether it's a default dummy, you find that relationships face more defaults. So that is the main finding of the paper, that firms will allocate their funds when in trouble towards transaction banks and not towards relationship banks. And then I do a bunch of robustness tests, including the for the measure, instead of the median, you use 75th percentile, only use distance-based measure, combine two rather than all the three of them. Then you control for loan amounts. You can think that, okay, the results you're getting only because firms default more on the larger, on the bank from which they have borrowed more. So I control for loan amount, maturity, collateral to the extent I can get it. And then there are lender level characteristics that can vary with time, and you can absorb them with lender cross time fixed effects. I look at subsamples of data where there is the one big question, or the first question that obviously comes is this effect also holding for private firms? And that is true. There's to an extent. There are public firms and there are public banks and private banks, and the results are much stronger for public sector banks, but this phenomenon is also present in private sector banks. And then you can also think of all sorts of other problems, like is the relationship lender lending at a particular rate, or they are taking a particular kind of collateral, and so on and so forth. And I can absorb them with firm cross bank fixed effects. And then the question comes, okay, even if you trust all of this, what I just said, that a firm prefers to repay transaction banks over relationship banks, so the next question is why? And the hypothesis is the firm perceives a lower threat of prosecution upon default from relationship banks, and that's why the firm does this. So do I find evidence for it? Yes. And I use debt recovery tribunals data. I scrape their website for cases against the firm, bank pair, and see, and in this period between 2013 and 2016, you see a drastic rise in DRT cases. I think RBI was tightening some norms, but I think others probably are better informed why this rise was there during this period. But for whatever reason, this rise in cases happened. Also SARFAESI was strengthened, so one of those things could have helped. But what I observe is the default, conditional on default, a relationship bank is much less likely to take the firm to courts compared to the transaction bank. And that's the direct evidence for threat to prosecution. And that was my hypothesis that I wanted to test, because the firm perceives a lower threat of prosecution from a relationship bank. That's why it defaults more on the relationship bank. And during the same period, you see fewer change in management. A transaction bank is more likely to inflict a change in management, and a relationship bank is more likely to make more loans and restructure more loans in that same period. Now the next question comes, why would relationship lenders do this? So I test the weak collateral channel, and then I also test this information channel. So there are two channels. One reason could be that relationship banks lend on weaker collateral, or they are trying to hide something. One of those two things could be happen, or both of them, those things can also happen. So first I tried that are relationship banks lending based on working capital loans. There's no difference between relationships and transaction banks in that sense, but what I find is relationship lenders are probably easier on the kind of collateral. They are taking weaker collaterals like receivables, which are more like compared to more stronger collaterals like immovable assets or something. But there's no difference here. I don't find the difference between relationship and transaction banks based on either more or less working capital loans or more or less receivables as collateral. But what I find, so next step is to check whether there are banks hiding something. And so, and that's where I find something. So there is a UN Varas paper in 21. It's a theory paper which says that banks would try to hide negative information about the firms they have lent to because they want to signal to the credit market that, okay, I continue to believe in this firm. It's not going down yet. And if they disclose that negative information, because I'm talking about relationship banking, I'm assuming that this relationship bank knows more about the firm than rest of the credit markets. It knows some private information, whether positive or negative, about the firm. And this information is private between the firm and that relationship bank. And because the bank knows it, either it can choose to disclose it or hide it. If it chooses to disclose it, what will happen is that the rest of the credit market will also believe that, okay, because the relationship bank is saying that, okay, this is a bad firm, everybody else will stop lending, and the firm is definitely doomed now. But if the bank believes that, okay, this firm may recover, it will try to hide that information, and so that rest of the market also keeps lending. And this is also, to an extent, a noisy measure that I have, where the relationship bank gives a new loan or restructures an existing loan of a firm, and at the same time, this firm makes a repayment towards the transaction bank. So that is what I call some kind of help, or trying to hide negative information about the firm. But this measure could capture both good firms and bad firms. But I find that firms which are helped in this way are more likely to receive more loans in the next period. But once the forbearance period ended, they were found to default more. So there was something wrong going on. These firms did not recover as quickly as the banks expected, and they were also using the CMI's CapEx DX database. You can also see that these firms which received some kind of help were more likely to invest in, they were not necessarily distressed firms, but they invested in projects which were somewhat like very highly likely to get stalled in the next period. So there was some enhanced risk taking, I think. Yes.
So in previous slide you were saying other lenders.
Right.
There are non-bank entities?
No, other transaction lenders. No, banks only, other banks, other than the relationship bank. And then what is the overall impact of this kind of, so then I also find, yeah, so I'm out of time, but this is also my last slide, so just another 30 seconds here, that what I also find in a smaller set of data that I separately collected is that banks are, relationship banks are lending at a higher rate, which if you also attended yesterday's presentation, there was a difference between how banks were stating their risk and their interest rates. That also sometimes seems to happen here, where relationship banks were charging higher interest rates, so maybe they're perceiving more risk there. But during forbearance, this was going well, and the banks were earning more profits, banks which were doing more relationship banking, but once AQR happened, they suffered heavier losses than the other banks. So I'll conclude by saying that information that banks have can be revealed to the market or they cannot be revealed to the market, and that will define how the firms perceive, that will guide also the firm's response towards the banks. So that's my presentation.
Related to the fraudulent. With your analysis, this heading.
Sorry?
So 35-40% of the default cause related to the fraudulent. I mean that funds are diverted by the promoters to the others.
Right.
That information is either we can say is hidden or something. I mean, with this analysis, is there any linkage? How we can improvise from the banking system point of view? All these reviews are done independently, all systems. But linking with these, how it could be improvised?
That's a bigger question. But I find that these results are consistent among the willful defaults and non-willful defaults. So I don't know if that question stands. I mean, if there was a very stark difference that willful defaults are, this pattern I find only in willful defaults, not otherwise, then that question made more direct sense.
Stage, willful, but the moment the funds are diverted, only the question is hiding the information related to this, how it could be, in the current context, it could be come out. I mean, how the banking could be aware about these diversion of funds which are being. That is all.
I think Mr. Bhan can answer that much better. It's a regulator question.
We know the things I mean. So
yeah, of
you
course.
said that's also correct. What I said is also correct. It's all about legal.
Sure.
Yeah.
Nice presentation.
Thanks.
Can you just go to the descriptive statistics?
Sure.
is around 2025.
Right.
Could you just help interpret that?
So that is new loans. The first row is new loans.
Okay.
The average new loan that
Okay.
a bank makes to a firm, and the overall outstanding loan amount that between a firm and a bank is larger.
And the default of 2%, is it in terms of the amount or the number?
Like a proportion of default.
Okay, if we kind of compare that with the NPA of overall banking sector, that is around 5, net NPA at 5% or gross NPA at say around 10%. Kind of difficult to interpret that.
Right. So I might have missed a few defaults. And I do not capture the smaller defaults that are smaller than 1 crore, but that is not there. Yeah.
And, just wanted to know from me, myself being a researcher.
And this is also, sorry, one more thing is this is also mostly, but that doesn't matter. Sorry, you were saying.
So another thing was that I'm sure it could have been a Herculean task to go through the entire TransUnion Civil and get all the NPAs. How did you go about it? Like
So
manually or?
Fuzzy matching between firm name here and firm name in the MCA.
Does
data
that
set.
require any kind of subscription with the TransUnion or anyone can
No.
access that?
It's a suits.civil.com website.
Okay.
It's available
So you
for
can get
anyone.
it. And just one last question as a follow-up. So when you are talking about your dependent variable is a kind of logic 1-0 default or not, in the existing banking system, as I understand, if let's say in a consortium, not a multiple banking arrangement, but in a consortium, as I understand, if a party defaults with one bank, so it's an NPA with one bank, so all the consortium lenders have to classify it as an NPA.
Right.
So keeping that in context, assuming that most of your sample data are listed firms or bigger firms, so don't you think that would actually not make any difference whether I'm paying to a relationship lender or a transaction lender? Because if I default with one, all are considered as default.
Yeah, maybe. But so what I'll do is, I believe that even if I throw out the consortium lending from my data set, the result should stand. But I can confirm that. I think it's a valid concern and I'll have to check. But I think in a smaller subset of data, I know which loans are consortium loans and which loans are not. And that subset is very small, like out of 4,000 or so contracts, I think some 500 or something are consortium. So I don't think their weight is as high to overturn this result.
Thank you.
Particular firm, right?
But there's one charge holder, right?
Yeah, that's whoever files the charge, right?
Yes,
but,
yes.
But the lending could have been a consortium.
Yeah, it could have been. It's similar
that's
question.
It's
It's not always, yes.
And how do you have the loan amount, like for each lender by a bank?
That is the loan amount that
No,
corresponding to the charge,
where's
right?
that data coming from? That's also the charges.
Yeah, charges data.
Right, so again, that's not the exact amount, it's just whoever files
Is the charge
charges
holder.
first, right?
Right.
And the
So
second,
whoever files the charge first, isn't the lead banker should charge the file the charge, sorry. That's not true, you're saying.
It's whoever files the charges first.
And the
It's
lead
not
banker would
necessarily-
just let anyone file it.
It's not necessarily a lead banker.
But is it probabilistically higher that the larger lender would hold the charge?
Could be. But,
Yeah. So
but
as long as that is true, I think
yeah, again,
should be fine.
But I don't think as a definition that's good. That whoever files.
Right. So this is the best data I could get. The second best data is with RBI, the acrylic data, which I don't have access
The
to.
next thing was that in the end you mentioned that the firms which are more into relationship banking, they tend to take up more riskier projects, etc.
Right.
So is this really a relationship
No.
banking problem or like a sectoral lending problem then?
These firms are from all sectors, but
Yeah, but you said that their projects are more likely to
Yeah.
be stalled. It may be that in some sectors, that's how these sectors run, such as infrastructure, etc.
Right.
So it may not necessarily be a relationship versus transaction banking.
because you're saying relationship banks are more likely to lend for infrastructure projects and then they're getting
That's
stalled.
just an example. You said that
Yeah,
these
I'm
projects.
just trying to understand the example.
Yeah.
But let's take it offline, so I understand.
are more worried about the quality of the loan than the quantity. So they don't differentiate between, like you said, relationship bank and transaction bank. So any stress is happening in relation to any CD, it is relayed around that this is the CD under trouble. So
Right.
relationship bank in that context should not have the advantage to facilitate loans from other banks to flow in for its payment. So I thought that
That was a bit far-fetched, you think? Yeah. My take was that, just to quickly answer that point, that they won't facilitate, but they have the liberty to not disclose bad information about the firm that they only know, and the firm knows. And that what they could have done instead was they could have just relayed this information quickly and not sit on it, a bad information that they receive, and that would indirectly facilitate more loans coming the firm's way. That's my point. It's a like indirect channel. I'm not saying that directly they'll arrange for loans or something.
Sorry. See, in your conclusion, you have given that regulator will keep a tab on firms. So, from macro point of view, it's fine. But you have data on an individual firm. Suppose some firm goes to IBBI for resolution purpose. So, you have some particular data because you have combined all the data.
I have combined the default data from CIBIL and loan data from it.
No, that's fine, but you have the data, suppose particular X firm or Y firm goes to IBBI.
That one I don't have. That would be nice to have though.
Yeah, I reserve my comments because I had already opportunity.
Yeah. Thank you so much.
So, Rajeshwari, yeah, welcome.
I just have one question, sorry, just one question.
Sure.
Which is, I'm not sure how you are defining relationship lending unless you have bank firm matched loan level data.
Yeah, that's what I
Because
have.
minimum, just you have bank firm loan level.
Yeah.
But I
That's
thought
the
it's
index of
distance
charges.
that you have.
Yeah, distance between the firm and the firm headquarter and bank lending branch.
But do you have data on the loan that the firm is taking from the bank? Oh, so I missed that.
Thank you.
Yeah.
Can we just use this instead of that?
Because this is recording is there.
Oh, acha.
Sir, before going, just one small announcement, sir. Just may I request the other presenters, whether they are present here or not. Kumar Saurabh Singh.
Don't know that.
Yeah, please.
Thank you. L. Vishwanathan. And Dr. Ghosh, Puranjay Ghosh.
All people are. Yeah, please check.
Under the second presentation of the session, so I'll just take a minute to introduce the presenter. So Dr. Rajeshwari Singh Gupta is an associate professor of economics at Indira Gandhi Institute of Development Research in Mumbai. She was a member of the research secretariat for the Bankruptcy Law Reform Committee that recommended the Insolvency and Bankruptcy Code for India. Her research interests are in international finance, monetary policy, banking, bankruptcy, financial markets, and firm financing. She completed her MA and PhD in economics from the University of California, San Diego.
Thank you to the organizers for including our paper in this program. It's nice to be doing IBC-related work again after a few years. I see some of the familiar faces who are also involved as part of the BLRC Research Secretariat. So this is a paper jointly co-authored with Harshvardhan, who's right here. So I'll do the presentation and he'll do the answering of questions, of course. So the paper is titled Corporate Bond Pricing in India, Drivers and Role of IBC. This is...
Yeah, it works.
No, but this is not the presentation. Wait, let me just get started in the interest of time. So a good way of motivating the work we have done is borrowers, be it corporate borrowers or individual borrowers, are essentially always looking for accessing the cheapest cost of funding, right? The cheapest cost source of finance from anywhere. And therefore, in order to spur economic activity, one important thing to do is to lower the cost of credit in the economy. And what we are trying to look at it is the IBC played any role in lowering the cost of credit, right? So it's the ushering of a new bankruptcy regime. It's a watershed event in the commercial credit landscape. Has there been any impact of this new bankruptcy regime on the cost of credit? Now, why is the IBC important as regards the commercial credit landscape? Because the IBC for the first time in India is a legal framework that strengthens creditors' rights, right? It establishes the rights of creditors in a very clear and well-defined manner in the event of a borrower defaulting. And therefore, presumably, the IBC would have changed the behavior of the creditors, because all the erstwhile legal framework that existed were significantly either more debtor-friendly or friendly towards a specific class of creditors, not essentially friendly towards all classes of creditors. Whereas IBC does not distinguish. By design, all classes of creditors can be a part of the committee of creditors, and therefore it's a significant strengthening of the rights of creditors. So what we do in our paper is we focus on a specific class of creditors, which are investors in the corporate bond market. And what we try to analyze is that has there been a change in the risk perception of the bond investors in the pre versus the post-IBC world? Very simply put, what's the research question? What has been the impact of the IBC on corporate credit spreads? What's the contribution of the paper to the general literature and to the discourse overall? To the best of our knowledge, this is the first comprehensive empirical exercise that analyzes the impact of IBC on the corporate debt market, or in fact on any aspect of the corporate debt market. And in the process, what we have done is we have put together a very comprehensive data set which contains primary bond issuances in India over a period of about 10-11 years, containing a wealth of information on who the issuer is, what's the issue size, what's the maturity, what's the coupon rate, everything, right? So that's a very important contribution, and it's a data set that can be used by all researchers interested in analyzing different aspects of the bond market. So IBC, of course, not required for this audience at all, but specifically a few aspects of IBC which are relevant for our work, which is what I started off with, is that it empowers all classes of creditors, secured, unsecured, financial, operational. That's a landmark change from the legal framework that existed earlier. Today, we might be very used to the IBC jargon that an operational creditor is triggering an insolvency case, or a bondholder, bond investor is doing it, but that was not the case earlier on pre-IBC, where primarily banks were the only ones who had access to any legal recourse for secured credit. So given this significant departure from this erstwhile existing framework, the important class of investors that are likely to get quite affected, important class of creditors, apart from banks, are the bond investors, are the bondholders. Because what we have to remember is that in the pre-IBC world, the bond investors, they didn't really have much of a right or much of a legal recourse in case of a borrower defaulting, right? And that has changed with the IBC. So it's sort of like almost like a quasi-natural experiment that these class of investors, these class of creditors did not have recourse to legal action in the event of an insolvency pre-IBC. And that has happened with IBC because IBC treats the banks as well as the bond investors on an equal footing in the creditors committee. So IBC, of course, is well known. And as I said, the hypothesis, therefore, that we are trying to posit is post-IBC, the creditors such as bond investors would demand a lower price for credit. Because their creditor rights have strengthened in a post-IBC world, they are going to lower the cost of credit because now they do have a legal recourse in case there is a borrower defaulting. Performance of IBC, so again, well known to this audience. It started in December 2016. Then the RBI initiated large borrowers, large defaulters going into IBC. Since then, many cases have come to the law. However, the law itself has been changed multiple times. Many regulations have come up, which themselves again have been amended. And data and anecdotal evidence shows that while the performance of IBC was relatively satisfactory in the first 2 years, but since then the performance may not have lived up to the expectations of the original objectives. There have been delays because of judicial, administrative, and logistical hurdles. There have been all kinds of disputes related to IPs and COC, etc. So for multiple reasons, the performance of the law may now be not as much up to the mark as it was originally envisaged to be. Why the corporate bond market? I was briefly alluding to this, that pre-IBC bond investors did not have a well-defined creditors' rights, unlike, let's say, banks who could go to SARFAESI. And one of the factors, therefore, responsible for the inadequate development of corporate bond market in India allegedly was this, that bond investors could not really take any legal action against borrowers defaulting. And now that has sort of been rectified with the IBC. Because the IBC, as I said, places the bond investors on equal footing with the banks. And therefore, we expect, again going back, reiterating the hypothesis, that IBC may have lowered the cost of credit as reflected in credit spread. So now I'm going more towards the technical aspect of the paper, that when I say cost of credit in the bond market, how are we measuring this? We're measuring this using corporate credit spread. And it's essentially the spread between the corporate bond yield and the government security bond yield. And I'll come more to that. So essentially, again, the question to redefine is, did the IBC lower the corporate credit spreads? Context in the literature, there are some studies which have looked at strengthening of creditor rights and what has been the impact on lowering the cost of credit. There is minimal work done on impact of IBC on the general financial system in India, particularly firms financing, nothing really about the bond market. Of course, there's the famous Vikrant Vik paper about the impact of Sarfezi, and then there are a lot of papers which look at the determinants of corporate bond prices. So our paper sort of fits into all of these strands of literature, because in the process to find out what is the impact of IBC on corporate credit spreads, we are also looking at other determinants of corporate bond pricing, which also hasn't been established in a very detailed way in India, perhaps for lack of data. Why is it important in the Indian context, right? It is important, and this is something that may not be important in an international context, where there is already a well-developed bond market, the bankruptcy regime has been operational for years, for decades. It's important in the Indian context because effective bankruptcy resolution is critical for bond investors to gain confidence, and also the bond market in India is highly skewed towards the highly rated bonds. The AAA and the AA rated bonds account for more than 85% of the bond issuances in the corporate bond market in India. And this is not a good thing, because there are a lot of lower rated bond issuers who need to be able to access the bond market, but they're not able to do that for lack of a liquid and well-developed bond market. But perhaps because of IBC, which is an effective bankruptcy resolution mechanism, at least on paper, all classes, all rated bonds can therefore, bond investors can come to the IBC. There's no distinction between what's a high-rated bond and what's a low-rated bond. And in fact, IBC might be more effective for low-rated bonds because the issuers of those bonds are more close to bankruptcy and more financially stressed compared to the highly rated bonds. Therefore, the study that we are trying to do can provide very important insights as to whether the ushering in of this new bankruptcy regime can play or has played an important role in the corporate credit market, corporate debt market. Very quickly, what do we find? We find that IBC did lower the credit spreads for bonds issued by the non-financial firms compared to bonds issued by the financial firms. So we do find that there is some impact, albeit a little bit of a weak impact, because it holds only in certain empirical specifications that we estimate and is not a very robust finding. We do find that bond investors seem to be paying more attention to firm-level balance sheet features such as firm size or firm financial health, as opposed to the effectiveness of IBC as a bankruptcy resolution mechanism. And this will become clear when I present the results. We also find that there is some impact on issuers of lower-rated bonds, but again, the overall impact is weaker than what we had started off with anticipating. And that could be because of the fact that IBC itself is a relatively new law, and for a law to actually start having substantial impact on the credit culture might take longer than just 3-4 years. What's the research design? So this equation here shows what is the expected loss that a bond investor is estimating, right? So the expected loss is the product of the probability of default and the loss given default, right? So assuming that there is a probability of default of the borrower, what is the loss given default that the investor is going to face? And at any point of time, of course, the investor is going to want to minimize the expected loss, right? So what we try to do is that the credit spread, which is essentially the cost of the credit across all the rating classes, would decline post-IBC regime because it would reduce the probability of default, because essentially, and most importantly, the loss given default, because now the bond investors have recourse to this legal mechanism. So the overall expected loss would come down, and that in turn would lower the cost of credit in the bond market. So what's the research design that we follow? So we try to do sort of what is called a difference in difference mechanism, where we treat the IBC as a quasi-natural experiment, because unlike many countries where bankruptcy reform has been a gradual and continuous process, in India, this was a one-off Big Bang reform that got enacted in May 2016, right? And the environment before that was completely different from the post-IBC environment, particularly, as I keep saying, for the bond investors. So we look at it as a quasi-natural experimental setup, And also, originally as it was designed, IBC was exclusively meant for non-financial firms. There are provisions in the Act using which the government can notify certain financial firms which can be resolved in the IBC, but the original design has always been that IBC is meant for resolving the insolvency of non-financial firms. So this kind of gives us a group of treated firms. So think of the treatment as the IBC, and the treated group are the non-financial firms. So this gives us an opportunity to compare the credit spreads of the non-financial firms in the post-IBC world with the credit spreads of the financial firms in the pre-IBC world, because IBC does not apply to financial firms by design. So we do get a quasi-natural setup, and we do get some kind of a treated group and a control group, which sort of helps us to identify the impact of IBC. So what are some of the hypotheses that we are trying to test? One is, of course, the main hypothesis that IBC would lower the credit spreads of the bonds issued by the treated firms, which are the non-financial firms, compared to bonds issued by the control firms, which are the finance firms. Okay? In addition, we also look at a few other hypotheses. One is that although IBC applies to all non-financial firms, one can argue that investors will sort of treat the public sector firms differently from the private sector firms, because public sector firms, simply by enjoying an implicit guarantee from the government, their bankruptcy probability is not going to be similar to what the private sector non-financial firms would have. And therefore, what we were interested to check is how does the impact of IBC pan out between PSU firms versus private sector firms within this larger group of treated non-financial entities. And the third hypothesis is that given that there are different rating categories and hence different categories of financially distressed or non-stressed firms, is it the case that IBC was more effective in lowering the credit spreads of the most financially distressed firms, which is the low-rated bonds issued by firms? Because the hypothesis would be that if indeed IBC is lowering the credit spread, the benefit would be felt more by the bonds issued by the firms which are lowest rated, because they are closest to being declared bankrupt, etc. So the baseline model, just even ignoring the equation, what we essentially try to do is encash on this treatment control kind of an identification setup, where we have an interaction term where IBC is a dummy, which is essentially for all the post-IBC years from FY17 to FY20. We stop in FY20 because after that IBC was suspended for 1 year during pandemic. So in this post-IBC period, what was the effect on the credit spreads of non-financial firms? So our variable of interest in this entire equation, if you have to remember one variable, that's IBC interacted with non-finance. Okay? So non-finance is a dummy for all non-finance bond issuers, and IBC is a dummy for all the years post-IBC. Okay? And the hypothesis is that the estimated coefficient of that interaction term, which is beta B3, that should be negative. That for all non-financial firms in the post-IBC period, credit spreads would have come down. That's the hypothesis that we start with. And we have a bunch of control variables because the data set that we use is extremely rich. So we're able to control for the issue size of the bond, the maturity of the bond. And then what we also do is we match this data with firm-level data set from Prowess, so that we are also able to control firm-level balance sheet variables like firm size and firm financial health, for example, interest coverage ratio, right? So after controlling for all of these determinants of credit spreads, do we see that there is an impact of IBC, and is it in the anticipated direction? And also I want to point out one very important issue side variable that we have in the control vector is default probability. Because one of the most important determinants of credit spreads in the bond market would be what is the probability of default, right? And we get the default probability from the credit rating agencies. So every bond is rated by credit rating agencies, CRISIL, ICRA, etc. And they also publish default probability. So we use the default probability as an explanatory variable. So having controlled for default probability, issue size, maturity, firm balance sheet features, etc., is there still an impact of IBC on the credit spread? That's the baseline question. And there are multiple ways we, of course, slice, dice, and look at the thing, because we're very interested to look at the effect. The data, which is a very important aspect of our paper, this is manually collected from the India bond info of NSDL, which essentially gives us primary bond data issuances from FY11 to FY21. Now, one thing we have to keep in mind here, which is a departure from international literature, is the secondary corporate bond market in India is extremely illiquid and underdeveloped. In fact, there is no price discovery happening in the secondary bond market, so it makes no sense to use secondary bond market data. What we use instead, therefore, is primary bond issuances, because even there is an important role to be played about the pricing that is getting done at the time of issuing of the bond, right? So we have, finally, what we use is more than 3,000 bond issuances at the primary market. These are all rated C and above. There are a lot of NAs in the data, we exclude them, but the rated NAs, meaning the bonds which have not been rated, but the rated bonds account for 90% of the data by value. So even by excluding the NAs, we are not really losing a lot of information. And we stick to FY 2015 to FY 20 because pre-FY 2015, the data is sparsely populated. So we sort of get 2 years before IBC and 3 years post IBC. So the sum stats basically would show that the bond issuances both by volume and number have gone up over the years, particularly after IBC. Also, we find that majority of the issuers, by the way, in the corporate bond market are financial issuers. Non-financial issuers account for about 30% of the total issuance in the primary market, but that's our treated group. So credit spread, as I said, we use, this is the difference between the yield of a corporate bond and similar maturity government bond. And for that, we use the zero coupon yield curve data that is provided by CCIL for calculating the government bond yield of identical maturity. So I'll just present two tables, and if it's too difficult to see, essentially the result that we find is that when we control for issue side variables such as default probability, issue size and maturity, etc., and we have year fixed effects, all of those in place, we find that IBC ended up lowering the credit spreads of the treated non-financial firms by about 60-65 basis points, there being a bankruptcy resolution framework. So therefore, the effect, though there is a statistical significance effect in some specification, it's not robust across specifications. Yeah, but still, I mean, 30% by value non-financial firms, 70% finance firms, but the average effect, I mean, the significance does not hold through specification. So it's there, but it's a relatively weak effect, so to speak. For what we find for the public sector firms, we have thought that for private sector non-financial firms, the lowering of credit spreads will be even more. We don't find any statistical significance of that effect. But we do find that for low-rated issuers in the non-financial sector, there is a relatively stronger effect. It's almost about credit spreads on average are reduced by 1.6% for the low-rated bond issuers in the treated group of non-financial firms, which is what we would have expected because, remember, these are the issuers which are much more closer to bankruptcy because they're much more financially stressed. So clearly, IBC is having some benefit for these kind of bond investors as opposed to when we pull in everything together with the AAA, AA, etc. So finally, last slide, we find, roughly speaking, it's a weak effect. It's not as robust as we researchers would expect in empirical studies where it's robust across all specifications. But having said that, we have to remember that this is only 3 years post-IBC. So for a law to settle down despite so much of amendments, etc., and have an impact on credit culture might take longer. Unfortunately, we can't go beyond 2020 because of that pandemic time discontinuity. But it's worth tracking this going forward because we were definitely encouraged by the fact that on average, we do find some kind of an effect even without controlling for the firm variables. And for low-rated issuers, there is a pretty strong effect of 1.6%. Also, I think what may have happened is over time, because of all the news and all the anecdotal evidence, there may have been a certain discontentment that has set in about the performance of the IBC. So the original confidence that the bond investors may have had about a new bankruptcy regime may have gotten dented towards the later part of the sample, and that may be moderating the effect to some extent. This is just pure speculation because we're just trying to understand why the result is not robust enough. But yeah, that's where I'll stop. So happy to take questions.
Very nice paper.
Thank you.
Paper also.
Thank you.
In fact, after maybe I think 2 years or 3 years back, I was motivated some of the students that can you see this one? Anyhow, that you have picked up and the evidence is available. Good. Any questions here? We'll take just.
Behram is not allowed to ask questions.
Yeah.
All questions to be directed to.
No, that's not fair.
He's a co-author.
My question is, how much of this dips which you are seeing is due to improvement in the volume per se?
Sorry, the credit spread volume, credit spread coming down because of increase in volume of bond issuances.
If you put in
Yeah, so within non-financial firms, if we just separate out the triple B and below, as opposed to the triple A, AA and A, the effect is stronger for the lower rated bonds.
Which will expect when they closer to bankruptcy.
Within triple A and AA, I don't expect there's going to be any effect at all. Yeah, there's a stronger effect there as opposed to when we pool everything together.
How do you control, like you have in the regression model, non-financial and financial firms are being.
There is a double variable because the issue on
No, my question
So the identifier is there in the data set itself.
My question
Yeah.
is, suppose in financial firms risk is high, in a non-financial firm risk is low, then also those spreads can be driven. So
yeah, but it's all rating, right? The rating will capture that.
See, once you control for default probability,
Rating agencies do that.
that's, yeah,
Every year
exactly.
rating is given.
ratings are little bit sticky as compared to what.
Sorry?
Ratings are generally sticky and
That's the only way we have. We have annual financials, not have monthly financials. Sorry.
Harsh, one minute. I go to
I think there are two questions from there also.
Sweta Chaneja.
Just out of curiosity, I wanted to understand whether the you have mentioned composition of bond issuers is skewed, 85% by one set of firms. Has that composition changed pre and post IPC? Have you checked that?
No,
That isn't it.
it hasn't. Not yet.
Can I ask?
Everything is, 3 years time frame is.
Hi. No, so first of all, thanks a million as always, fantastic study, presentation, everything. Couple of points. One is I think very, very clearly as practitioners we found a pre-COVID, post-COVID. So I'm not sure about 19, but it was definitely much more effective. Pre, then you came to a stop, so the car it's not like a EV, it hasn't taken off yet. So second, as you again correctly said, it was not meant for financial institutions, but de facto now we've had 3, so
Yeah.
it will be very interesting to see
Yeah.
whether
The later data, if we gather.
later data, yeah.
See,
We stopped at 20.
DHFL and all started towards the very end
At
of our
20,
sample.
20,
Yeah.
yeah.
So that's
it
not
made
even a
no
part.
sense. And Shrey and RCAP are still.
Yeah, yeah.
But very fair. But the one thing I want to say, of course I'm biased, so it's good if Harsh replies, is that credit culture, if you talk to banks, any FCs, they say there's already, and you said it 3-4 times, it's a very short time frame to change a country's credit culture, but they see a huge change already.
Yeah.
That there's definitely a credit culture change. And the last thing very quickly is, on the 65 basis points, and you're saying that the large and the small,
Yeah.
etc. My partner raised a very good point that was the time bank credit was pretty
Was
squeezed.
shrinking.
So
correct.
they had more bargaining power. So I still think the 65 is good.
But Bairam, to that point, bank credit to the corporate sector still hasn't picked up. Banks are lending more to the retail sector. So if banks shied away from the corporate sector, then that trend has continued even after the COVID thing. So I don't think that's going to have much of an effect.
Yeah.
Sir, very quick question. You mentioned that
Sir,
the lower rated bond investors would be closer to bankruptcy. Did you see that to be true?
But that is
Like, because you said probability of default is what you use, which is the ratings from the agencies.
Much higher.
So how close for the higher rated bond investors of bankruptcy? Do you have any idea on
No.
that?
This is just a conceptual idea. Right?
See, that's also not what we were interested in, because it's like, let's say you have 3,000 bond issuances. Some are rated C versus some are rated AAA. Of course, the default probability of the C-rated bond issuance is going to be higher than the AAA, right? Much higher. So therefore, it made sense for us to do the separation of the lower rated and higher rated. Now, how close they are to the bankruptcy frontier, that's a separate question altogether.
Madam, just one question.
No, so unfortunately, we have the pre-2015 data, and we do plan to go back and take a look at it, but unfortunately, it's much more sparsely populated. So you have many more missing observations and NAs in the pre-2015, whereas 2015 onwards is relatively more coherent.
See, when we have missing data, it's a very painful thing of manually going to websites and getting. So it takes an enormous amount of time. But we intend to do that.
It's very interesting paper. Thank you, sir.
Thanks, Aparna.
I have collected some time back these primary issues going to the NSE website. I'm painfully taking all the coupon rates.
Just putting together the data.
That page.
Yes.
Yeah.
30,000 issues.
Yeah, that's what we have the data with me.
I think there's a question there.
Sir, my question to you is, the effect, the desired effect that IBC was expected to have on bond markets, do you, in your study or in your overall assessment, do you think that the effect has not been felt also on account of the outcomes in the resolution process and the judicial approach to, say, interpreting issues in insolvency?
Yeah, so there are two types of variables that would be relevant, which we could not parameterize. One would be the quality of resolution, time taken, number of errors, so there is no authentic source of data on this. Conceptually, I agree with you. Because our past years are around 60 odd percent. Some of them could explain the remedy. But in a regression, you need a hard data, which is objective. We could not get that for some of these.
I think this is why we submitted to the IBBI conference. If IBBI can give us some data on IBC specific performance metrics.
Codify the data of time to recovery, errors and so on, so that we can look at it.
So, sir, as practitioners, what we also see is that the comparison that you are making, that banks had SARFAESI, bondholders didn't have SARFAESI. Now, I think all bondholders today want SARFAESI, and that in a way is also expression of their confidence in the insolvency process and the IBC process. Because more you talk to the bondholders and the recommendations they give, simplify and ease access to SARFAESI. So they want effectively bank-like regulatory regime. That in a way is also something for regulator to consider why that is happening, that there is entire move to become a secured creditor when you are entirely positioning this law as a very big reform for bond markets.
Somebody views that the situation banks were here, bond market says now they are here, they are still here. So they don't have the kind of
So the reason why I said bond investors didn't have SARFAESI, etc. is because earlier there was an asymmetry. Now IBC has put them on the equal footing. And the only thing that we are trying to look at it, does it reflect in the credit spread? Because that should ideally.
Yeah, last. This is just a clarification regarding default probability. Because in your table 7 you have not shown the source also. Because in other tables you have shown the source as NSCL. But these three rating agencies, Bristol, ICRA and CARE, you have done the average of three agencies. Then how?
Yeah.
So what happens? Every bond is rated by this one.
The data which you have taken, this is average of all these three agencies or what?
So what happens? Every bond is rated by one or more. Some are rated by two. They are rated by two, we take the average. They are rated by one, we take the agency which has rated.
Okay. Yeah.
I think there was one more question there also.
Yeah, sorry.
You can talk at lunch.
You can take
We have noted your request as a regulator. You said data sets are needed. We are considering.
So I can give you a very long list.
So we will love to have that. But my question is basically on your conclusions, which I thought Bairam Sahab has also pointed out, that if your data set is for 20, then how can you say that the system starts going down? Because it all started after 20. So that concluding slide was a mismatch, I thought.
No, what we were saying is that for first to FY17, FY18, there may have been a little bit more confidence because this was a new bankruptcy law that came in. And that may have tapered off a bit even before the pandemic, given the delays of resolution, etc. But you are right, post-pandemic, it may have become even more pronounced. There was some way for us to understand why the effect is not robust. But as I said, another reason is also because it's a relatively new law. So 3 years is not good enough for that effect to happen. Yes, thank you so much for all the
Sorry, I'm disappointed. I appreciate your enthusiasm. But we have 3 more papers. And I request the presenters, please avoid the background because we are all here. Most of us know about this background of this. Straight away, please come to the paper and your conclusions. Paper and conclusions are more important.
Mr. Kumar Saurabh Singh is a partner of the Banking, Finance and Restructuring and Insolvency Practice Group in Khaitan Company. He has significant experience in organizations' debt financing, including asset financing, project finance, trade finance, so forth. He focuses on insolvency and restructuring. This is going back. How do we go in front? Of some of the largest non-performing assets in India. for Sector 16,
Can you go
second
to
power
the first slide?
constructions. And with him is Ashish Ramaiya.
Yeah, you go
He's
to
an
the first
associate
slide
in the
here.
same company.
Just go to the
And
first
he
slide.
graduated from NLSIU and has a keen interest in division. Over to you, Ravi.
Thank you. Thank you. Thank you, sir, for giving us this opportunity to present our paper on role of promoters, rethinking the role of promoters management in resolution of corporate debtor. I think this issue, as sir was mentioning, is very well known to all of you, so I'm not going to go too much into background. But as you are aware, under the insolvency and bankruptcy process, once the formal insolvency process commences under Indian law, the powers of board of directors is suspended and shareholders do not have any formal rights. And it is a creditor in control model which is supervised through an insolvency professional who is appointed first by the court and then by the committee of creditors. And it is the resolution professional and the committee of creditors who are involved in running the affairs of the company during the insolvency process, and also say in running the overall resolution process. Now, from the time that the law was introduced to the subsequent amendments and where we have reached today is that the role of shareholders and management has substantially reduced, not just in running the affairs of the company and the resolution process, but also in participation in the overall resolution process. Now, whether that can be relooked at, looking at the, say, experience of last 6 years, I think there is an argument to really consider the whole legal regime around this. And we wanted to really cover some of the say key issues around insolvency resolution and how 29A can be relooked at in terms of say more engagement of promoters and shareholders, which can be a positive incentive for a better resolution while keeping the entire undesirable elements who have say been involved in wrongdoing clearly out of the process, but at least incentivizing those who have been say affected on account of business failure, because there is studies which do show, at least even in Indian context, that there has been a contribution of price movement, say in metals and other industries, which has contributed to default. And if we look at that as a significant contributor to default, then this whole approach of entirely eliminating shareholders from participating in the process, whether if that can be refined, can it give a boost to the process? Because we saw in the last presentation also the rate of recovery and the overall process has faced its own challenges in last few years, partly because of pandemic and other issues. But could it be, say, further strengthened through, say, changes which can really, say, give more participation to all stakeholders and not be completely eliminating a section which has clearly initiated the business, brought it to a scale, and is then completely left out of the process because there is a default. Now, if we look at insolvency resolution, now some of the other markets which have had more robust insolvency regime and experience longer than India, you will see that, say, the US regime, the Chapter 11 regime that we all know it as, that regime is a debtor in control model. So that model really keeps the onus of running an insolvent firm with the management and does not take away their powers at the beginning of the process. At the same time, there is say clear thresholds that if there is wrongdoing, if there is fraud, if there is mismanagement, which is seen during the process, then clearly there can be a trustee appointed. But the first opportunity to find a resolution is given to the people who are closest to the business, and if they can't come out with a time-bound resolution, then it's a competitive process. Even at that stage, it is not eliminating competition. Now, if we look at the regime in UK, under the UK regime also, it's a creditor in control model closer to the regime that we have gone for. But even under the creditor in control model of UK, while the creditors step into the affairs of the company in running the affairs, there is involvement of a resolution professional administrator, as they call it. There is opportunity for companies' voluntary arrangements to be proposed. It is an opportunity given to the existing shareholders and management to really give the first shot at resolution. If that doesn't work, you still have a process where there is competition, but there is participation. So you are seeking cooperation possibly by allowing participation by shareholders and management. So that is the bargain through which you possibly get more cooperation. And ultimately, it's a competitive process. If there is a business failure, in attempting its revival, there is a competitive process through which price discovery of the asset can be done. And depending on who gives the best value, the asset goes to that party. Now, if we look at the Indian context, now clearly we have removed that distinction between fraud, malfeasance, and business failure in a sense of, if you look at 29A and the resolution regime. While the fact that shareholders are not involved in resolution and management of the affairs of the company during insolvency, that of course is a regime which has parallels in other jurisdictions. In our context, we have an additional element of non-participation of shareholders management in attempting a resolution. And formally, they cannot say submit a resolution plan and be in competition with other stakeholders. Now, that regime, when it got introduced in 2017, it has been litigated and it has gone through litigation and has been upheld by Supreme Court in multiple cases. So from a legality standpoint, there is really no doubt regarding validity, legality of this regime. But if you look at, say, extension of the regime under 29A, which was introduced initially only for IBC, now that has been extended through regulatory approach for pre-insolvency workouts also. If you look at, say, RBI regime on restructuring resolution pre-insolvency, that disincentivizes restructuring with existing shareholders. There is also restriction on trading of loans with anybody who may be 29A disqualified. In a pre-pack regime also, there is completely a 29A assessment and valid compliance with 29A, which is required even in liquidation. So clearly, from an Indian standpoint, we have extended this eligibility threshold not just for formal insolvency resolution, but for liquidation and pre-insolvency processes also. Now, result of that may be seen in the number of successful resolutions that you see pre-insolvency. Now, if you look at period between, say, 2005 to 15 and say post 2017 period, the number of pre-insolvency resolutions have substantially come down, because for banks, there is really not much in it if they restructure with the existing shareholders. So clearly, banks would always look for a change of control to to really get benefit of resolution restructuring. And in the process, say, even the 29AC, which was intended to give 1 year to existing shareholders to find a resolution, may be becoming to an extent unworkable because of the regulatory disincentives which are there to work out a resolution. And ultimately, what we see mostly banks really looking at either change of control or a one-time settlement process where they would be seeking settlement from, say, defaulting firms, and which would mean that these firms either, say, promoters bring the money or they raise financing. Now, in a default situation, that may not always be a very clear option or an easy option to get, but the fact that you are not really having a shot at trying to work out a resolution, in a way, whether that really aids the process is something that we have to consider. This is somehow not. If we look at, say, from the point of time that this law was originally introduced also, I mean, the initial Bankruptcy Law Reforms Committee and its initial approach to this whole resolution was really to make a clear distinction between a regime which is, say, recognizing business failure and not penalizing people for business failure, except that in the process of workout, obviously the investment that a shareholder has made will get wiped out by the process of resolution. But there is no penal measure for default, but in 2017, in the wake of large resolutions that metal sector saw and some of the other sectors, there was that perception that involvement of a promoter means that you are condoning a wrongdoing, while temporarily that may have been reaction to the circumstances at that time. But today, when we have benefit of say last say 5-6 years resolution, and also some of the studies which have been done which really corroborate that there is a correlation between default and say price movement, I think there is say this is right time to really look at the insolvency regime and see if there can be tweaks around the law. I mean, both in insolvency and pre-insolvency. Say in a pre-pack RBI framework, why do you disincentivize banks to do restructuring when 29AC itself gives them 1 year? And in a formal process also, can there be more clear, say, quicker assessment of fraud wrongdoing? Because on one side, we have a 29A ineligibility, and on the other hand, if you see the record of really, say, even 10 cases which have been heard and decided by courts, which really lays out any principle on fraud and wrongdoing. So, on a mere presumption that there is business failure, therefore you keep out the shareholder, as against that the outcome of, say, audit and a court process really leading us to a more considered, say, decision to keep a shareholder out. I think that's really the choice that is there before the process. And I think if, say, there can be, say, more evidence-based, say, action rather than a presumption-based approach of keeping shareholders completely out, it can possibly lead to more cooperation, because today what we see is that you go and file applications in NCLT for seeking cooperation from management, nothing really comes out of it, process ends, but the application is not decided. As against that, if you really create a framework which is seeking involvement of all stakeholders, and at least in pre-insolvency not removing room for involvement of shareholders, I think there could be, say, different results. I can't say that it can really lead to better outcomes, but there could be different results. And in a country where you are looking to really promote entrepreneurship, and if you see the kind of say growth that we have seen, now if you really want to encourage that entrepreneurship, do you want to create a legal regime which is very unique to us, where on mere business failure you completely lose the firm? Now, how does the two balance? And
can you just come to the conclusion part of it? What is your suggestion on this?
Sir, my
problem is not too many of
yes.
Yeah.
The suggestion, sir, really would be that in a say pre-insolvency resolution, one can look at say not making hard distinction between shareholder and others.
Yes.
And if there can be other tools like securitization, if a bank can't hold a defaulted asset, let there be securitization, let some market participants hold that asset, but not put it such a hard and fast rule to keep them out. And even in insolvency, if there can be audit in a time-bound manner, that in first 45 days or first 60 days you complete the audit, and on that basis you take a decision that if there is a prima facie evidence of fraud, keep the person out. But it cannot be that you complete a process and fraud issue is not determined for 5-6 years, but you have already penalized the shareholder who may have set up and brought the business to a scale.
Yeah, okay. Thank you. Yeah, sorry, we are out of running time, so this topic is been debated since a couple of months, and people who are in the insolvency regime, this area topic very well about it, known about this one. Yesterday, President NCLT mentioned about whether artificial intelligence is useful. So we can say whether artificial intelligence can discriminate the genuine promoter with the fraud intention promoter, so that the problem may be solved. Probably judges can take a call. Am I right, sir?
Sir,
Yeah.
no comments?
Yeah.
No comments?
Yeah, we will defer it for you. He is available for tonight. Am I right, sir? Yeah,
So,
you
sir,
can,
only one
But I want to let us hear
just one thing for Kumarji, that it's 18 months. So hopefully the default is only more than 18 months. So hopefully, but all the older cases now are gone. In COVID time we had the moratorium. So now the idea is that come before 18 months. As long as you come before 18 months, you won't get it. Because BARA plus the NPA plus the admission.
No, but
so
Behram, you see, I mean, in a formal process, of course, I mean, 18 months is a point, but you look at pre-insolvency, like in a matured economy, what is the volume of cases that have been restructured, and why that is not happening? Is there something which is disincentivizing banks to restructure?
So same thing, the feeling of government and policymakers is you come by 18 months. Even pre-ITC, don't come so late. Why you want to come so late? Because we all know the later you come, the worse the assets deteriorate. So tell everyone, okay, boss, the minute you are 18 months is long time. Yeah. Of course, I am aware what you are saying. We are away from all modules, but consciously so. Jaldi karna hai.
Okay. I have here Mr. Vishwanathan and
Mr. Animesh and Mr.
Anish and Karan. And Mr. Karan and Anish, one small request again. The Vidarbha Justice case is widely debated. So please give the opinion on that one without much too much of the background. Sorry.
So while they sit up, I'll just quickly give. Okay. Mr. Amnish focuses on corporate insolvency, banking, finance, and regulatory litigation. And Karan with us is an associate with the dispute resolution practice of the same company. He's also contributed to the monthly column titled Insolvency Law and Review. Over to the
before in hard cases and the challenges that we are facing in light of some of the recent judgments. Why hard cases? Well, I think, of course, while we get into the deep dive into the cases and the analysis, what is important to sort of note is the judicial underpinnings of why a principle-based approach is paramount to, evaluating any law. And I think that's what we found that in some of the recent judgments, perhaps the principles have been given a go by, the fundamental principles, or what I would like to call the grund norms of the code have perhaps been diluted in light of some hard cases where special equities of the Insolvency and Bankruptcy Code have taken a backseat to the equities that the Supreme Court or the NCLAT may have found particular in that case to be charitable to some extent. In the words of Justice Oliver Wendell Holmes, great cases like hard cases make bad law, and these are some of perhaps the bad laws that we discussed. Essentially, hard cases, what I mean by hard cases is that there perhaps is no direct rule applicable, or where the rule that is applicable can generate something conflicting. Emergence of hard cases is largely due to unique factual environment of each resolution, and this is, of course, we have seen each resolution is different, pose up different equities. A balancing of conflict of interest of stakeholders, inherent incongruities arising in the implementation of any economic legislation. The paper advocates that in deciding any of these hard cases, a principle-based approach, that is placing reliance on principles, rather than merely applying the literal statutory provision, is the way forward. The structure of the paper, I'll briefly discuss the legal philosophy, and why I want to discuss the legal philosophy is to just establish that even in the greatest of debates on what is law, by Professor Hart and Professor Dworkin, they both agreed on one thing, and that was that a principle-based approach is necessary when understanding, either discovering or inventing the law. What is the approach taken by Indian courts in hard cases? The underlying principles of the code. We'll distill a few which we believe are the bedrock principles, which are the grund norms, which can't be given a go-by to, and then examining certain hard cases under the code. Just spending very briefly some brief discussion on this. The debate was, what does a judge do? Does the judge make the law, or does the judge discover a law? Professor Hart was of the view that a judge can invent the law, can make the law when there is a gap. Professor Dworkin was of the view that a judge merely discovers the law. But what they both, and in the postscript, there was a debate that went on back and forth in the Harvard Law Review, but in the postscript after even Professor Hart's demise, which was published, he himself admits that while inventing the law also takes into account various factors, the principles, the underlying sort of grund norms, the morality of the legislation, the objects are paramount, and that can never be given a go to. So whether you call it discovery, whether you call it invention, the principles are paramount. However, in Indian courts have, of course, the judges always say that, look, we don't legislate here. Even if they do indirectly do it, they will never say that we legislate. We only discover and we only tell you what the law ultimately means. And I think I found a very apt quote by Justice Krishna here. It says that to be literal in meaning is to see the skin and miss the soul. The judicial key to construction is the composite perception of the deha, which is the soul, which is the body, and dehi, which is the soul of the provision. So, of course, what the paper seeks to study is that if you take the historical background of the code, if you look at the parliamentary debates, if you look at the aims and objects of the act, then the cases that we are about to study, will the conclusion have been the same, or will it have been anything different? Next slide, you just go to next. These are some of the principles that we identify as the key principles of the code. There are different weights to each principle, and even Professor Dworkin always recognized that, while you have 5 principles, each one will have different weights, and sometimes you'll have to balance one against the other. But in really no order of priority, but in some order of importance, these are what we call the essential principles of the code which cannot be given a go-by to. Early identification of stress. And by this we mean early identifying when a company is required to put into the rigors of insolvency. That means when there is a default and when there is a debt due, when there is a default, you immediately go to the insolvency court. And there is no point in waiting for recoveries or waiting for a potential resolution of the balance sheet if the cash flow is not working out. Because once that happens, we have situations like Vidarbha. the creditor in possession model. This was the paradigm shift that Innoventive talked about, that unless and until you remove the entrenched management out of the company, there will not be any judicial discipline when it comes to insolvency and bankruptcy. Judicial discipline comes from the fear of losing the management of the company if you are not able to resolve. 29A, of course, is a very deep discussion, and of course, there's a lot of back and forth as to whether in these situations the creditor, the erstwhile management can come back, and it can very well so do that. But this paper advocates that at the point of inception of admission, the management must move out and must be given to a professional. There should be limited judicial intervention. This is the fundamental provision of the moratorium. This is also it also rests in the principles of the wisdom of the COC being supreme and not being interfered. Resolution should be in a time-bound manner. The importance is both on resolution as well as on time-bound manner. Resolution means that liquidation should be a last resort, but at the same time, where early resolution could actually mean liquidation, it should not be left, to unnecessarily go through the rigors and, with promoters and bidders constantly coming up with higher bids where the COC has made up its mind that liquidation is the way to go. Maximization of value of assets, promotion of entrepreneurship and availability of credit. I think this is a big debate after Rainbow Papers, because if the government dues were to suddenly be given priority, the whole object of the code, which was to ensure that the credit is available to the financial creditors, and if the credit is available to the financial creditors, that automatically gives a boost to the economy, which results in sort of a domino effect for the government exchequer as well, rather than government coming and claiming first dues.
Let me ask you, don't mistake me.
Sure. I'll just lay it out because all our judgments we'll analyze on this basis. Balancing interests of all stakeholders and the binding nature of a resolution plan. I'm of course referring to EBICS here. The first paper I want to discuss was the Rainbow Papers judgment. I think there's a detailed paper on this in the second half also. But the question here was whether government authority should be treated as a secured creditor. Now, just at the outset, if you look at the very object that's set out in the preamble of the code, it is to reorganize the priorities of government dues. So, with that in mind, taking a government due and putting it in the same light as secured creditor has very fundamental problems. First, let's just see what is the most obvious thing that this judgment has failed to consider. 53(1)(e)(1) of the code clearly provides that all state and central government dues are lower in priority to the financial debts and even to unsecured financial creditors. So while 53 is a specific provision under the code for distribution, there is a specific provision therein which treats government dues as a separate class of creditors which is lower in priority. With that specific insertion, in our respectful submission, the Supreme Court has not considered the true weight and import of 53(1)(e)(1) and has looked at the general provision and the general definitions of what a secured creditor is to say that where a government or a state statute creates a charge, the state government or the central government automatically becomes a secured creditor. They have also failed to look at the definition of transaction, which underpins the definitions of security interest. Because transaction, while it's an inclusive definition under the code, it's a definition which clearly has a meaning and import of a commercial transaction or a commercial agreement, which has to be the bedrock of the creation of the charge and not a statutory provision under law. Go to the next one. Vidarbha Industries is the other judgment which we think is another hard case. Of course, here there was a great discussion on how there are certain dues which this entity was about to receive in the near future, and because this company would have in the immediate future, according to the Supreme Court, been an ability to pay its debts, the court was of the view that we will look at this balance sheet of this company and look at the ability of this company to pay its debts in the future and not admit this company. Now this, according to us, is an absolute harakiri against the court, because we are going back to the old scheme of ability and inability to pay debts and the balance sheet test on deciding, which was applicable to the winding of provisions, and not the cash flow test. Because we have to realize that IBC is not a winding up provision. IBC is a resolution provision And if you look at the early identification of stress principle, the moment you go to say that the ability has to be looked at, you lose your sight on the early identification and early indicators of stress, which a default over 1 crore is. Of course, I will not take too much time on what may and shall is. I think we are all aware that courts, depending on the legislation and how the context is set, may can always be shall. And in this case, of course, our submission is that the word may there, as has been held by Justice Naraman in Innovative Industries, should obviously mean shall, because there is a limited scope of review which precedes the section may admit, which is that the default is there and the application is complete. The next case is JP Kingston. JP Kingston was on dissenting financial creditors, and it brought about the principle of disembarking the ship by dissenting financial creditors. Essentially what it said is that since the dissenting financial creditors have not agreed to the plan, they cannot be saddled with the implementation of the plan. They cannot be taken along for the ride. Give them cash, let them go. But this again goes against the very fundamental principle that there is a 66% majority, and there's a commercial wisdom that has been given to the majority that binds the minority. If you take away this, then the binding nature of the plan, which binds shareholders, stakeholders, government authorities, effectively gets diluted for dissenting financial creditors who can demand cash and walk away. And look at the problem here. The problem here is that you will only know who the dissenting financial creditor is after the plan has been voted upon. So after the plan has been voted upon and suddenly you have 25% dissenting financial creditors, the RA would be expected to either pay that amount in cash or allow for some enforcement of securities that may be exclusively charged to them. So therefore there cannot be a negotiation which is premised on these kind of contingencies. And this is a problem that becomes quite difficult in large transactions where there is a consortium lending. There are a lot of common securities, common pools where important assets can therefore be put into jeopardy because of the principle that has been laid down in JPs. Karan, you want to take these two?
This is the last one.
Yes.
Yeah, this is the last one. And the conclusion.
Yeah, so recently we have witnessed that the NCLAT has come up with some interesting judgments in regarding the aspect of the computation of liquidation value payable to dissenting financial creditors holding security interest. Now basically the liquidation value of a debt is in a liquidation scenario considered on the basis of the security that is available to a financial creditor. Because in a Section 52 scenario, the financial creditor can enforce the security and be able to satisfy its debt. However, the NCLAT recently basically has upheld the decisions of the COC to determine the liquidation value of the debt of financial creditors as per their voting share rather than the security interest. Now let me give you an example in this regard. Let's say I have lent 100 crores to a company and taken as security a second-hand car worth rupees 5 lakh rupees. You as a lender, you have also given a loan of 100 crore rupees, but you have a security over a prime land that belongs to the company in the heart of the city. So your loan is secured by a security of 100 crores, whereas my loan of 100 crores is secured by a security of 5 lakhs. Now what would actually happen is that by the report of these judgments is that as my voting share, let's say we are the only two creditors, and I have a voting share of 50%, and you will also have a voting share of 50%. I made a bad commercial decision of giving a 100 crore loan maybe on the basis of 5 lakh rupees of security. And however, because of the report of these judgments, you will basically whatever is the resolution amount, that will have to be distributed equally. So this basically takes away from the fundamental principle that the legislature has also intended to recognize, that the pre-insolvency entitlements, the assets over which the creditors have their security interest, that should be recognized. And the UNCITRAL legislative guide which the IBC also heavily relies upon, that basically cautions against inclusion of any measure that would take away the security, the prior pre-insolvency entitlements of the secured creditors, because it would directly affect the cost of credit. And the corollary of the same is that if the secured creditors are not able to recover their they recover their loans in spite of having good securities, they would be wary to lend the money, and it would exponentially increase the cost of credit as such. So basically this has serious implications for the availability of the credit. One of the reasons for which the code was introduced to remedy that, because India was deemed to have one of the lowest levels of credit availability in comparison to the size of its economy. Now, just to conclude, basically in numerous judgments, Justice Nariman had also recognized that basically this code not only deals with economic matters but also the economy of the country as a whole. So the economic experiment under the code should be preserved, and the code should be judged by the general provisions rather than the inequities and the incongruous situation it generates. Let's first say Vidarbha as an example. Let's take Vidarbha as an example. The code got weighed by these case-specific inequities. Basically, the application was filed on the basis of a debt due of 550 crores approximately. The company was expected to receive 1,700 crores on the basis of an APTEL judgment. The court basically thought that the case-specific equities there should have an influence because the company is expected to receive such large amounts and they should be able to resolve their debt. But this judgment had severe ramifications on basically the scheme of the code, where it has been envisaged that on the basis of furnishing information of debt and default, you should be able to initiate proceedings under the Section 7 of the code. So, just as a concluding thought, the interpretation of the code should be necessarily and firmly rooted in the principles that have been formulated, and we should try to avoid to get weighed by the case-specific inequities, because that would result in us going back to the pre-IBC era, where basically it was a highly fragmented nature and we had sort of lost sight of the actual objectives of the insolvency regime. Thank you.
We have last presentation. I request, because the concept is well debated again, maybe your model or solution can be given precisely.
I will try my level best to keep you posted. Thank you. Can I take this paper as a reference? This paper.
Puranjoy Ghosh completed his post-graduation doctoral degree from University of Burdwan, joined civil practice, and he subsequently joined teaching profession in 2002, and now he's working as an assistant professor at School of Law, AIIT. Over to him directly.
Yeah, whatever the request put down and the discussion so far going on since the very beginning of the session. I have noted down certain points from the first speaker, Mr. Nitin, to the last, the partner Cyril Amichan. I will take my audience to have some implications from the Merchant of Venice, to refer something that I feel some implications are there. Like when Bassanio concluded the decision, it was a financial impulsiveness to take loan from Antonio, who was actually not having the cash in hand. So the particular personal trust, the first speaker, obviously, the first speaker categorically mentioned, and this is actually appreciable, relations, lending and transaction. So that was a relationship lending, fantastic, but the collateral was not thought about. It was based upon trust, complete trust. So net worth was actually intangible, cannot be quantified. Now, as Antonio didn't have anything, so Antonio concluded the decision to be the bond before the money lender side. And Shylock, being the inhabitant of the same locality, Venice, actually aware of, not to the fullest extent, but to a certain extent, the net worth of Antonio. So each one was, relation, although not completely quantified, but each one was having such impression about the net worth of the other. Based upon that, but Shylock, being the money lender, a businessman, he looked for the bond. And that bond was, whatever be the terms of the bond, Antonio agreed, and based on that, the lending was enlarged to Bassanio. Now, when Continue concluded to be the guarantor or to be the bond in front of seller. It was personal in nature, without any collateral, easy for the purpose. I mean, there is a least amount of recovery, although equity, the special contract, that the surety can have the opportunity to recover it from the principal debtor in the event of default. But Silock had something out of that bond, so that instrument could have been triggered. Now, Silock enlarged the loan, which was actually floating in charge. If we think from the company language of the Companies Act, floating charge, fixed charge. It was floating charge in nature. The moment it was crystallized, it becomes a fixed charge. So it was triggered. Now, the implication is that the relationship lending, and perhaps the first speaker concluded that in case of relationship lending, a recovery chance is less. The second speaker concluded that the cost of recovery, that is the cost of recovery, and whether now, insofar as the monetary economics is concerned, more circulation of the money actually helps to develop, helps to enhance the economic growth. If the focal point is entrepreneurship, if the focal point is, the main object of the IBC is a rescue mechanism, then if we look at the data so far available in the website, maximum NCLT decision has gone towards the liquidation process, more than 50%. So primarily, the two aspects, we can take four elements for our consideration. Number one is economic wisdom is given much preference than the judicial wisdom, which is why the hands of the adjudicating authority have been tied or rather restricted, and the supremacy of the priority has been given to the decision of the COC with a benchmark 70% value. Number two is the last presentation with regard to the Dawkins concept. In law of constitution, we have come across with equality and proportional equality. And the provision of proportional equality is under Article 15, Article 16, which is why subsidized scheme has been enlarged for the purpose of actually growing of the socially and economically disadvantaged group in India. So that subsidized scheme for the purpose of the minority group in the business circle or the descending creditors, that has not been addressed in the IBC, which in the previous presentation it has been made clear. Now, may I go through my slides one by one? Combination cooperation approach. In cooperation approach, what is very much necessary is the trust and information symmetry. If one is aware of the maximum and transparent information about the other, then trust will automatically be built up. And if there is a trust, lending and trust is there, then it will be open-ended platform where free exchange of the information and the least amount of asymmetric information will be there. So mediation helps it out. The appointment or the guidelines in the IBBI with regard to the IF, the Insolvency Resolution Professional, is very much focused to the technical aspect of the recovery rather than the rescue mechanism, where both the parties, without any hindrance, can freely talk to each other and come to the conclusion that would be helpful for the rescue mechanism. That is absent, and no such guideline in relation to this mechanism has been appreciated in the legislation. Opportunity to minimize erosion of the value of business, very component, contributory, element of that. Minimal scope of holding out issues, fair bargaining, all these are quite visible, I suppose. If anyone is having any question, I can obviously address on completion of this presentation. Analytical methodology, I have taken analytical because it is a combination of the substantive approach, as in the last presentation it was made, Hart and Dworkin concept, that interpretation of the law. Interpretation is required in order to give a predominance of the judicial wisdom to enlarge and cater out the equality to each such stakeholder, not only a group of stakeholders who will having the majority value out of the total default. So that is the functional role of the judiciary, and then only the justice can be catered out. So, which is why analytical, and it requires a review and analysis of the pre and post of IBC and a comparative study of the other developed economies and developing economies, how in their legislations they have addressed this balancing factor, how they have harmonized, which is why analytical method And empirical some indicators I have taken into account, but I couldn't find the time to collate the data and to come up with this data for the purpose of the presentation. But these are some of the indicators I have taken into consideration, where based upon the secondary data source, the collection of the data, and one empirical survey may be made, empirical study may be made. There are two concepts that I have come across with this. This is a concept, laid as concept is in the in Belgium they followed it, wherein the members are mostly from the businessman who looks for the market failure and the chances of market uncertainty, whether there is a chance of market uncertainty in the upcoming days because they are having the business acumen, and the economic failure, financial failure. So if there is a financial failure, that may be the internal factors and that can be taken into account within the fold of the governance, and the default would be the willful default. But if it is the market uncertainty and market failure, in that event, it is non-willful default, and for that purpose of rescue mechanism should be given much preference, which should be decided by the adjudicating authority. Thank you. I will very soon conclude. In that case, the judicial wisdom should give predominance rather than the economic wisdom. Market test is very close to that in UK practice, very close to that market uncertainty, where economic failure and the market failure have been taken into consideration. And private arrangement before the commencement of the court proceeding, we are having that pre and post initial phase in our PPIRP in 54 capital A, but the clear division, which is the pre-initial, which is the post-initial, where it will be informal, where it will be informal, that has not been clarified in the amendment. Now these are the loopholes, the challenges I consider are to be taken care of. No clarity in the mixed approach section of the pre-initial that I have just mentioned. Approach of CRP is to explicate PPIRP in case of ambiguity. Appointment of IP as RP instead of mediator. Functional role of 54 capital P at par with IRP and CRP uncertainty default higher value departure from the unsettled model, and not consider the company's mediation rules 2016, which categorically mentioned for the purpose of addressing this type of distress, financial distress of a company while running. In particular, Rule 4 for mediation, Rule 11 for the procedure, and Rule 828 for the ethics, that is to be taken into consideration. Now, some papers are coming, keeping this particular insolvency regime from a different perspective, that is masculinity and femininity. The feminist approach with regard to the moral hazards and ethics, and masculinity is the rigidity and rigid interpretation. Some papers are available. Mediation is in between to make a balance and harmonize to actually protect the interest of all the stakeholders, and a nice conclusion with the giving predominance to the judicial wisdom, and where the recovery will also be very much peaceful and in a time-bound manner, if mediation can be included within that resolution, dispute resolution mechanism. And issues preferably considered in mediation is use of cash collateral, because this is insofar as the transaction lending is concerned, this is the unique, a selling point of the banking man in the financial creditor. They look for, and they are very much focused to the recovery while they are enlarging. Before enlarging the lending, they are focused to the recovery. So naturally, this is to be given predominance. Obviously, keeping in mind a balance to be made with regard to the unsecured as well. Continuance or modification of the automatic stay, these are the issues where actually delay is getting when it is being challenged by some of the stakeholders in relation to the ongoing resolution process. And few primary issues not addressed with regard to the mediation, though it has been mentioned, and not in a direct, in an explicit manner, but with the court may enlarge if the court, this is the discretion of the adjudicating authority, but hardly it has been given effect to in any resolution process. And these are the issues to be taken into consideration if the mediation is having, if the ADR is to be given any significant role in the dispute resolution process, then these are the issues to be taken care of. And this is the conclusion.
Thank you. Thank you very much for respecting the time of all of us. Right. Maybe we can take one or two questions.
Sir, if I
Are there
If I
any
do
cases, yes sir, the mechanism is there, are there any cases where it has been, this mediation has been successfully?
So far as the resolution process, it has not been inculcated, and this is not the cup of tea for the COC at all, because they are looking for the recovery. Simple thing.
It must have happened,
That's all. So,
not all the court, but it must have happened without being in the liquidation. There is a section allows for 90 days, the promoter can take a compromise that route.
Then the sir,
Case of now, this mediation is
obviously sir, then the first, why the last speaker mentioned that stress, distress, financial distress, whether for the market failure, whether the chance of revival, whether there is any point of return, there is no platform kept open, and the judicial wisdom has not been given predominance in comparison to the economic wisdom. And so IBC has been framed in this way that the economic wisdom is to be given, all the surface is there, RDBFI is there, and nevertheless IBC has been a contributory tool, legal tool for the recovery. So actually the resolution rescue mechanism is not given much preference, although it has been mentioned in the object. Which is why mediation may have that significant role to achieve the object that has been set in the object clause of the IBC. That is my conclusion.
yeah, okay. I think we have, it's time to go for lunch. It will take 6 minutes to 6 to 7 minutes to walk up to FDC. 2:30 again we are assembling in the same complex.
Sir, one quick second, we want to facilitate Professor Jaydev and Dr. Surajman. Thank you for chairing the sessions and adjudicating.
Suraj would like to say anything? Sorry.
See, all the 5 members presenter, they deserve my compliments. Good research work done, so we'll see in IDBI, we draw points from these research paper, and then probably it will help our amendment or the further policy issues. So thank you all. Thank you.
Sorry Suraj, naturally this is my classroom, so I expect you to move around, so don't disturb me. Okay.
I would like to call Professor Debajyoti Das to facilitate the chairs with mementos. The other memento is for Professor Jaydev. Thank you, sir. Thank you, sir, for giving the focus. There is a claim form for the presenters that you take present and then take subsequent claims and reimbursements. And we can all proceed for lunch.
Same place, FDC yesterday wherever we had goods, FDC goods, same place.
Model law on cross-border insolvency in 1997 to standards and not strict rules, which allows for its provisions to be open to judicial construction by member states. Hence, quality need not mean the complete and unencumbered adoption of the model law by member states. There exists a need to restore a balance between the individual interests of the state and the collective interest of ensuring predictability and uniformity. The model law accordingly places reliance on institutions such as courts for its implementation as per the needs of that particular nation. There are a couple of cases in which cross-border insolvencies have been implemented in India, but this has been done by the NCLT on an ad hoc basis. The Indian approach to cross-border insolvency can be gathered from draft C of the report of the ILC constituted by the MCA in March 2018. CBIRC thereafter made recommendations on draft C and submitted its report in 2020. With the legislature beginning on the enactment of a CBI framework, myriads of insolvency proceedings have been affected. 6 subsidiaries of Rolta India Limited filed for reorganization under Chapter 11 of the USBC, which was dismissed. Meanwhile, the CIRP of Rolta India in India has not commenced. Another example is of the infamous Firestar International Limited, in which only the part claim of Punjab National Bank was allowed by the US court. Firestar was thereafter admitted in the IBC in 2019, and the NCLT passed an order commencing its liquidation. Furthermore, the US proceedings revealed that there are 12 other Firestar entities spread across various countries and 16 other shadow entities. In these scenarios, had there been a cross-border insolvency framework in India, and CIRP had commenced, the Committee of Creditors would have filed across jurisdictions and could have yielded higher recovery. We then have GCX Limited, which is a subsidiary of Reliance Communications Limited. CIRP had commenced in India against RCL in May 2018. GCX thereafter filed for reorganization under Chapter 11, which consisted of 16 entities regulated by the laws of various countries. This attempt by GCX was successful, which resulted in a debt-to-equity swap by senior noteholders who became shareholders. Could the RBI in India have filed an application under Chapter 15 of the USBC for cross-border insolvency, arguing that the foreign main proceedings had to be in India, as RCL's center of main interest was there, along with the filing for a group of companies? Yes. This would have happened had there been a CBI framework in India. Indian creditors would have benefited greatly from this. The inadequate cross-border insolvency framework in India has proved detrimental to Indian creditors time and time again. No legislation has been passed over 2 years since the CBIRC submitted its report in 2020. Some complexities that could arise in CBI cases will now be discussed in order to encapsulate the complicated nature of Bankruptcy. Establishes a hierarchy which places the registered office of the debtor at the top. The CBIRC has recommended that the said hierarchy be done away with, as a main interest cannot just be gathered from a registered office. Such an approach is apparent in the CBI frameworks of the US and Singapore. Moving on to the definition of a debtor. Draft Part C has included foreign companies under corporate debtors, the definition of which is derived from the Companies Act. Foreign companies are defined in Section 242 of the Act as companies incorporated outside India with a place of business or conducts any business activity in India. So, in the event that the foreign debtor has no place of business or business activity in India, they would fall outside the purview of Draft Part C. The domestic creditor would be left with no remedy under the CBI framework. It is for these reasons that the CBIRC recommended the inclusion of a definition for foreign companies under the IBC as limited liability entities incorporated in foreign countries as envisaged by Clause 1(2) of Draft Part C. The MCA and IBBI would have to amend the Companies Act and the IBC, respectively, to prevent any and all overlaps. Further, the CBIRC has recommended that foreign representatives be regulated by the IBBI, along with an online mechanism through which foreign representatives would have to submit an application to the IBBI for authorization at the time of applying to the NCLT or immediately thereafter. The IBBI's authorization is by no means a condition precedent to approaching the NCLT, and if there is a rejection by the IBBI, it would be reported to the NCLT, which would then issue orders as it sees fit. The courts would have to draw the boundaries of the powers of the IBBI and itself in this regard. In the event that cross-border insolvency laws are enacted in India, there would be a statutory framework in place with clarifications. Nevertheless, There are certain uncertainties accompanying such clarifications which buttresses the need for courts to step in. Courts accordingly have a mammoth task ahead of them and need to be endowed with considerable authority to pass orders and judgments in this regard, a concern that will be dealt with my co-presenters now. Ryan, the floor is yours. Thank you.
Good afternoon, everyone. My name is Ryan Joseph. I'm going to take you through the genesis of cross-border insolvency to highlight the unparalleled role played by courts in the entire process, to finally establish my argument that courts need greater powers when administering international insolvencies. At its heart, a cross-border insolvency process is a process created by courts to make it easier for foreign creditors to access assets of domestic debtors. In fact, cross-border insolvency was never created by the legislature. It was created by the courts in the case of Solomons versus Ross. In that case, the courts of Great Britain took cognizance of the extraterritorial implications of international insolvencies and allowed foreign creditors to access assets in UK, and thus came about the concept of CBI. Now, in the interest of the time, I'm going to take you quickly through the 3 reasons that justify the existence of a CBI process. Number 1, international insolvency does not happen in silos. It is a collective process where all stakeholders must be present to ensure an equitable distribution of value. Number 2, universalism and the comity of nations. Now, these 2 factors run hand in hand and are parallel to each other. Now, here I would like to take your attention to the case of INRE African Farms, where Chief Justice Inez remarked that if we are able to recognize and assess the foreign creditor, we must do so, for that is the only way the assets here in England will be duly divided. The modern legislations that we have today, such as the Unilateral Model Law or even the Draft Part Z, which still needs to be implemented, these legislations are based on the fundamental principles that were laid down by courts centuries ago. This begs the curious question, how is it that the court in African Farms, back in 1764, create a process with such manifold consequences without the slightest tether of support in legislation? My friends, the answer to that question is in the inherent powers of common law courts. Now, here I would like to take your attention to the case of Cambridge Gas, where Lord Hoffman explicitly noted that in the absence of a statute, common law courts have the power to recognize foreign creditors, and these powers and these rights must be equal to the rights of a domestic creditor. Similarly, Justice Millett in Credit Suisse versus Cohey remarked that commercial necessity has encouraged national courts to cooperate with international courts, and they need not wait for the sanction of an international convention. In the interest of time, I'll ask my co-speaker, Mank Sharma, to take it forward from here.
Thank you. I'll keep my submissions short and crisp. So the next and final fold of our presentation brings us to the challenges of inter-court communications to member states that are a party to the CBI framework. At the outset, it is necessary to highlight the need for a cross-border framework because of the inadequacy of the Code of Civil Procedure as well as sections 234 and 235 of the IBC. While section 13 does provide a binding value of foreign decrees, the NCLT's role is not that of a conventional code. That is why it doesn't have the inherent jurisdiction to entertain any such foreign decrees and enjoy the role that a conventional code does. That brings me to the part where the role of inter-court communication comes into picture, because the primary reason behind the failure of the current mechanism is its inherent inability to cooperate with foreign courts. The solution to this problem lies in GIN guidelines, which were conceived in 2016 in Singapore. GIN guidelines, also known as Guidelines for Communication and Cooperation between Courts in CBI Matters, envisage a network of insolvency judges around the globe in view of addressing challenges specifically posed by CBI through a modified universalist standpoint. An example of such a modified universalist approach is the Inverworld insolvency case. Inverworld, a North American company, duped investors of hundreds of $millions across multiple jurisdictions. in Latin America, as well as the Cayman Islands and England. With the intent of avoiding parallel proceedings, the court agreed to allocate different functions to each of the courts, and that every decision taken by a court would be binding on others. This not only led to a significant reduction of costs that incurred during the process against a tripartite jurisdictional battle, but also became a cornerstone of GIN guidelines 14 years before they formally came into existence. Theoretical underpinnings aside, modified universalism also restricts the scope of a public policy exception to come into picture, since it confines the invocation of the public policy exception. This has been derived in the case of Qimonda AG, which was a landmark case which delineated the broad contours of a public policy exception and when the same can be invoked. Finally, to conclude our submissions, I would like to end with one of Thoreau's quotes, which sum up the situation of the CBI framework in India. If you have built castles in the air, their work need not be lost. That is where they should be. Now put foundations under them. The construction of the castle of cross-border insolvency laws in India began way back in 2018 with the ILC's draft Part Z. What remains to be seen is whether the foundation building up to the castle is as strong as the sentiment behind incorporating a CBI framework echoed by the insolvency fraternity. With this, I thank panelists and everyone present here.
Thank you, Ryan and Sangeeta, for the full presentation, quite comprehensive and beautifully presented. And it's complex and a lot of aspects we have summed in the presentation. So I'll first open the house for questions, if there are any questions.
Hello, I'm Shivaswamy. I just want to ask you a couple of things. One is the absence of cross-border insolvency regime in India. That has, if tomorrow suppose it is also incorporated, it will only facilitate foreign traders to proceed against debtors in India. It does not actually anyway help Indian companies from realizing their assets which are abroad. Okay. Even in the absence of that, as we have seen in case of Jet Airways, Indian creditors, financial creditors are able to realize because that cross-border insolvency regime is recognized abroad in other countries in Europe, US and other countries, even in Singapore. So they could proceed against it for whatever it is worth, even if they have recovered 1 penny also, something has been done, something has been done. Cross-border insolvency, when it happens, it should also recognize whether the court proceedings here are acceptable in other countries. So that is again a big question mark, because again there are a lot of variations across the globe, and where, for example, chapter 11 in the US overrides everything. They say even if the company is incorporated without any financial stake, that will be treated as an area of common interest. So they will override everything. So these are all so many problems are there in incorporating it. What I want to know is what is the limited scope? Within the limited scope available, how much IBC has been able to recover? We have seen Jet Airways, it was not a very big success, and we also seen Firestar, it has been a disaster also. Okay. And Videocon, you have mentioned, Videocon is, I think, it should be an apology to IBC, not a success of IBC. Because again, 66,000 crore, if you are recovering something like 2,500 crore rupees,
I think, sir, your question is that
yes.
Your question is objectively on the recoveries, that
yes.
You want to know whether the cross-border insolvency law is going to increase in the recovery for India,
yes.
or is going to increase in the recoveries for foreign creditors. Right.
Thank you for the question, and it's actually a very interesting question because that precisely is one of the most contentious issues with international insolvency regimes. Now, the thing is, at a individual-centric level, right, when the Indian regulator by themselves have a look at the international insolvency regime, that is a very valid issue. However, to create a global consensus, right, the first step to enabling Indian investors to recover assets from foreign jurisdictions is to have a global consensus. And part of developing that global consensus is that each nation state lend its arm ahead and be there to reciprocate the action that we expect from other jurisdictions. So definitely, that most certainly is an issue, but that is an issue only when every jurisdiction does not equally reciprocate. But this mere risk, okay, that we may lend our arm way too early and other jurisdictions may take much longer, and in the interim period, it's only the foreign creditors who are going to benefit. We are most certainly incurring that risk, but if every player were to work with that risk, we would never have the global consensus.
Actually, the country which is more powerful, they are going to have their way. Okay, even in case of extradition, we have seen not even a single person has been extradited to India, but we have been
I
extradited.
think we are exceeding that brief.
Same thing applies to the recovery
expedition was with respect to cross-border insolvency. So, thank you for your question. Anybody else?
Can I comment?
Yeah, please.
If we talk about creditors, they have all the rights. So ultimately, if this cross-border can help resolutions, it can be a win-win situation for all. The resolution can happen if or some like in jet case where some assets are stuck somewhere, those cases can be resolved. So it can create a win-win situation. Even now, all the creditors have all the rights. Foreign creditors have equal rights as the Indian creditors, and that has been settled in many cases.
Yeah, right, sir. Thank you so much. That was one of the motives for us to write the paper as well, so that there is a possibility that everybody can have a win in such situations.
I have a question. Why is it called draft part C?
I'm sorry.
It's because it's still draft. I think the board would be better to answer that question.
Basically, the Insolvency Law Committee drafted it and they named it like this.
So I think the idea is that it will be a separate chapter in the code. So instead of writing it chapter 5, they just mentioned part Z. So not a chapter but part, so it's in parts. So we don't know, but it's just that whenever it is enacted, it will get the appropriate name.
Maybe they were not so optimistic when it will be inserted into the code.
No, I think the intent was there that it has to be inserted into the code. It will be a part of the code. But you would know better.
So the idea was that whenever it is put in place, it will be at the end. And
at the end.
So
whatever parts we have till now.
Feedback will go to the pipeline, so that will be also.
So basically that's what I'm saying. Maybe it comes first or feedback comes first or details come first. So when it depends when it comes. It's better to play it safe. Maybe that was the purpose.
Okay, so just one last quick question. So I have identified at least 3 or 4 issues. One is public policy challenge, one is the inherent powers of common law courts, and some problems with the drafting, interpretation, and the GIN guidelines. So which of these 4 do you find is the most critical?
I'm sure sir is referring to this slide.
I'm not referring to this slide, I'm just whatever I heard from your presentation.
Sir, we think that all of the issues merit a consideration for the IBBI, but we think that from an ICA perspective, International Commercial Arbitration, one of the fundamental issues that are plaguing the enforcement of an award in that scenario as well is the public policy exception that comes into place whenever an award comes into question. And I think that is one of the things that the IBBI should keep in mind while drafting a public policy exception. Because briefly, the draft part C does mention a public policy exception, but one of the factors is that it allows the government to state that exception and claim that this violates public policy, which is why we cannot enforce this.
So thank you, but I have my reservations because insolvency is not subject to arbitration. So there will be some jurisdictions which allow arbitrations. However, as far as I understand, that might not be possible. That is without taking out.
So I was just drawing a parallel.
That's fine, I understand. I think, thank you, but it was very, very comprehensive and I really enjoyed
Ms. Alankrita Pathak. Greetings to the chairs, the panel, and all my fellow presenters. This is Jaysha and myself, Alankrita Pathak. We both are third-year law students from Gujarat National Law University. And our presentation today broadly falls under the ambit of real estate insolvency. And our broad objectives would be, firstly, to give an overview of the process of insolvency which exists today in the real estate sector. Then we would move on to discuss what are the loopholes in the same, and then we would make an attempt to provide a model, a workable model which would be more effective in contrast to the process that exists today. Sure. Surrounding insolvency engagements involving real estate companies are complex and dynamic from other sectors due to the intricate group structure of the corporate debtors, the committee of creditors, and thousands of home buyers involved. So here, there are other regulatory authorities that are involved as well, such as RERA and other state authorities. So one of the primary reasons why the authors feel that there is a need for a different model is because real estate sector is one of the most capital heavy industries of India. If it falters, the economy can get greatly affected, as was seen in the case of Evergrande crisis in China, would be dealt with later on in our presentation as a case study. It is clearly visible that the IBC still does not offer a workable answer or a comprehensive strategy for protecting home buyers. Here we would make an attempt at highlighting the issues that the home buyers face and how that could be tackled. Coming back, firstly, we would go through a run-through of the existing insolvency framework. So, under section 7 and 9, the IBC offers the chance to the operational creditors and the financial creditors to file a resolution application to the adjudicating authority, which has to be accepted or rejected within 14 days, as may be the case. There's a certain difference between financial and operational creditors that has been laid out in the code as well, and there are certain benefits that the financial creditors obviously enjoy over the operational creditors. That was a contentious issue as to the issue of home buyers. Now, after the application by NCLT is admitted, it appoints an interim resolution professional whose main job is to constitute the committee of creditors, and after the committee of creditors is formed, they appoint a resolution professional who could be a new one, or they could appoint the same old interim resolution professional as the final resolution professional, and then they work on making the final resolution plan by inviting the EOI and then submitting it to the adjudicating authority. And failing which the time limit or any other legal implications, the company might be pushed into liquidation as well. And the main aim of IBC was to prefer resolution over liquidation. So now coming to the issue of home buyers, so we have been through a run-through of how the insolvency framework really works in India. So coming to the specific sector, that is real estate, wherein the home buyers are the major stakeholder, we would show you how that is the creditor class, how the home buyers were considered to be operational creditors, and hence the dues or whatever in the liquidation process, they were really not prioritized. And for that, we'll make a run-through of the waterfall mechanism in IBC. Here we have the waterfall mechanism in IBC, which is under section 53 of the Insolvency and the Bankruptcy Code. So, the priority in which the financial offerings by the resolution applicant shall be distributed to the secured creditors through the insolvency proceedings is determined by the, you can say, hierarchy of the creditors, which stipulates the arrangement, which is shown here. Now, so as we could see that earlier the home buyers were just considered to be unsecured operational creditors, but through a number of cases, the most important one of which is the JP case, Chitra Sharma, along with a number of home buyers, filed a case against the JP Infratech company, which was pushed into bankruptcy for protecting the rights of home buyers. Through the judgment in that case, which became a basis for an amendment in the code in 2018, the home buyers have finally given the position of secured financial creditors. Still, there exists some loopholes in the process which will further be elaborated by my colleague here.
Okay, thank you, Alantrita. So firstly, when we look into the whole mechanism of how home buyers are treated, we see that first there was a confusion as to where home buyers lie altogether. And then in 2018, we had a clarification which stated that home buyers are financial creditors. But the problem lies in the very concept of getting home buyers or tag them as financial creditors. The basic underlying factor of a financial debt is time value of money. This principle is indispensable when it comes to financial creditors. This classification is inconsistent for the following reasons. In Nikhil Mehta and Sons versus AMR Infrastructure, it was held that apartment buyers could be said to be financial creditors if they received a recurring sum as to the advance which they had paid. But then we see in another case of K. Bevat Engineering, in which there was a similar arrangement like a home buyers and real estate companies, where the court held that when we put home buyers in such a category, we are essentially creating a loose backing for the definition, and this would lead to a lacuna, as then there will be several operational creditors who could also fall into the category of financial creditors, and it would then create a problem in the waterfall mechanism. So as this being the basic problem with this, now I would go towards the regulatory framework which we attempt to pose, and to honor the paucity of time, I would directly jump towards the regulatory framework. Okay, so we all have known that now and again legal transplantation has been one of the fundamental tools through which a country resolves a lacuna of their legislation, and they look to the peer countries for the same. So in our framework which we suggest, we also looked into other countries and tried to take up certain solutions from there. So firstly, we go towards UK. UK used to be a creditor-friendly nation, and during COVID it changed its stance to a debtor-friendly nation. Their stringent payment holiday was now got certain leniency, and they also started allowing short-term finance in it, which is something which we also propose. Is real estate companies are one of their backbone of they're highly capital intensive and are backbone of a country. So when we think in that sense, we also need to give certain leeway to these companies to attain short-term finance to clear off their debts, which is in interest of all the stakeholders. Secondly, we pay emphasis on the CVA agreements which are present in the UK system. In the UK system, CVA agreements are limited only to future payment of debts by to the creditors and does not contain much other clauses. But what we propose is that when we pick up the ADR system which is present in Japan, or let's say France, which has a safeguard proceeding, which is something which can be added in the CVA agreements. Moreover, what we would like to advocate here is that in the regulatory framework which we propose, what we would like to see is that there is this deadlock which is present here. So what first we can do is that the home buyers go in voluntary agreements with the real estate companies, as well as a standard agreement in which they get the allotment. Over this, the payments which are received by the real estate company should also be diverted in a sense that they have some time value implication and they have some recurring incomes coming in. Due to this, because it's a common notion that they do not use all of the advances they receive on the very first day. So after this, in the CV agreements, there should be a clause of having bank guarantees for all the home buyers for the allotted sum. What happens due to this is the need for classifying home buyers extinguishes to a point of minimal, because once a company goes into insolvency, the home buyers can then use this bank guarantee to get their sum back, and now the bank comes into play, which is already a financial creditor and has a clear position in the waterfall mechanism also. Second, as we are also providing leeway to these companies, we should also look into the US system of avoidance claims, in which mainly there is a monitor which looks into over the company to just see if they are not going into any fraudulent transactions or transactions which are related party or somehow not beneficial to the stakeholders. So basically, we're trying to appoint two people here. One is a monitor who would be from the side of the COC who looks into the functioning of the company,
And second is the administrator. The administrator is one of the most crucial person in the Chinese system, as there are three parties in the Chinese system: the administrator, the court, and the creditors. The administrator stays in the company. Currently in India, what we see is that the board of directors is replaced by the IP or some other person. But here what I'm saying is that we should have the board. As it was said in one of the previous presentations in this conference itself, that these people are one of the best people as they know the company and its assets in and out. So when we have administrator who looks into their day-to-day activities, what happens is that we have best people who are supervised by one, an administrator who also helps them in liquidating the assets, and second is a monitor who takes care that the rights of creditors are nowhere misplaced or they are taken care of simultaneously. Moreover, what we also suggest is in the Japanese system of ADR. Why we say we need ADR? Because when there is a CVA agreement in place, it would include things like debt to equity swap and other financial tools as well. And we see that we have other financial tools to identify where the company's health is going. This is similar to a safeguard proceeding in France, where when a company is solvent, but is found that it is entering towards insolvency, at that time there is a person who does not essentially start a proceeding and halt the company, but looks into that it gets a sandbox landing and it's not a hard crash which companies go through. And coming to ADR, this can be one of the most efficient method, as we learn in economics about the highest valuing owner and transaction cost and other economic principles which talk about efficiency. Over and above this, the French system also talks about judicial liquidation and appointing a judicial liquidator. So one of the things we see here is that at the end, when none of the CIRP formats work out for liquidating the company, that's when we go for liquidation, and then we have NCLT playing its role. But other than NCLT, we also should have the administrator, the monitor, and a judicial officer who is a judicial liquidator for the same, and ensure that even government has its say. Because as we believe in separation of powers, but a company is not, even going in insolvency is not completely the jurisdiction of the judiciary and not the government. Because at the end of the day, it also affects the economy. And at last, there was this one small concept in Germany, which was regarding auctions. So the thing about auction is that in cost theory, we study that the asset should go to a highest valuing owner. So auction is something like that. Supporting this, in one of the recent judgments of Tata Infrastructure, the Chennai NCLT held that there could not be project-wise insolvency claims. And when we suggest this model, we also open up the possibility for the same. The thing about separate insolvency proceedings which are project-based rather than companies, that a whole project can also be auctioned or certain assets can be auctioned. And auction is a known mechanism for getting the highest value for any asset. Like this, we ensure that we get the highest returns so that we, the home buyers or even any other creditors do not suffer. The reason we pay so much emphasis on home buyers is that even under Section 18 of RERA, we see that as a country, we want our home buyers that they do not suffer. In India, we see we have a huge middle class, and let's say we go for even a 2 BHK property in Mumbai, we see it as high cost. And even the advances of the same are high. People need to take loans even for the advances, yet they purchase home. So when the company goes into insolvency and the home buyers do not receive anything, it's a peril for same. And lastly, I would just like to, in a crisp manner, summarize the implications of Evergrande crisis and apply this model there. So in Evergrande crisis, the basic outline was that the Chinese government put limits on debt. They called it the 3-line limit. And due to which Evergrande could not borrow more and went into insolvency, and it affected the Chinese economy as a whole. So we see that they did not get a soft landing. And as we can see both the charts, that in 2020, it was at its peak, and then it has a drastic downfall. And then even when we see the equity index property, which is based on the prices of REITs, which are real estate investment bonds, they also plummet, and even the high yielding bond indexes. So this is how the real estate sector is pivotal to an economy. So now when we suggest this model in something like an Evergrande crisis, having CV agreements in place, having a monitor and an administrator looks into that there is maximum return for all of the assets. And having project-wise insolvency also suffices that if there is one project which is not having adequate funding, then the same is segregated or severed from the whole company. Because what happens is that home buyers also are not always legal professionals or educated people to know when a company is going into insolvency, take their money back. And moreover, they do not even understand that company being insolvent is the way in which the Indian insolvency law works. So when we have such a model, we see that when we sever one of the project, it does not have a cascading effect on the other project, the company, and then on the economy as a whole. And that's how, okay, so this is how we look forward to applying the mechanism, which lays emphasis mainly on the CVAs and having more number of supervisors at the same time. So yes, this brings us to the end of our presentations. Thank you.
Thank you, Mr. Lankata and Jay. Interesting presentation, lot of references to foreign jurisdictions, processes.
Sorry? Of yeah.
My basic question is, a builder has taken 50 crore rupees loan from the bank and another 50 crore rupees from the home buyer, and he has not executed, he has not the project. What is the solution to it? Somebody has to come and put in another 100 crore rupees, and how, from where you are going to find it for financial? That is a basic problem. This home buyer will not get the possession of the project unless the project is completed. And to complete the project, you need to pump in another 100 crore rupees. Who is going to fund that 100 crore rupees? That is the basic problem.
Let me just rephrase for you. That was also one of the questions that I wanted to ask. You have tried to take reference of several jurisdictions, something in France, something in Japan, something in UK, something in Australia, something in US, and so on. By the way, were you present in the morning session where this gentleman from Japan was presenting their restructuring plans? It was very comprehensive and interesting. It's not just area which you have mentioned, it's quite comprehensive. And maybe you could look into Japanese processes, how they cover restructuring and insolvency. But still, let's say this is an application. Out of all of those jurisdictions, suggestions that have been presented, which one do you feel might address this question?
Sir, I think the CVA might address the question for the reason being that when the home buyers receive their money, we at least ensure that their rights are safeguarded. And now bank being a financial creditor, which is well within the waterfall mechanism, there is no doubt about it. So what we are doing is we are going from two ends simultaneously. At one end, we also want to maximize the returns which come through the insolvency proceeding. At the second end, we also want to.
What we also look for is how do you suggest that this can be incorporated into the code. So that's fine as a principle. But then where, in which principle, in which provision, or in which regulation in the code do you feel there is a need for any change or amendment?
Sir, more than any amendment which is required in the Act, we could make certain things like the CV agreement a norm for all the real estate companies to enter into the same. Because we see that real estate companies, when it comes to home buyers, they do not have something like or not only home buyers, they do not frequently use debt to equity swaps and something like that. Moreover, we also see that we already have indicators. That's what I was saying with the safeguard proceedings, that when we have indicators. Yes.
No, sir, it was the same, just like it said that we don't want to amend a particular section per se. We're just suggesting that making certain sector agnostic safeguards for this real estate sector with regards to the process as to introducing CVAs and certain other things that my colleague mentioned.
So this Chinese company crisis that you have.
Yes.
This Chinese company, what I understand is more than real estate. Real estate is just a very small part of, one part of this company. And then China had 2-3 years back changed a lot of regulations
Yes.
And it is because of this change in regulation that this company also had problem, but other companies also had problem. So, I mean, what little I understand, this is really, I mean, this company's problem were really not housing related, they were change in regulation related. And then I believe there were some problems relating to junk bonds also, relating with this company. So, just relating that this company had real estate problems, and we can equate it with the real estate problems in our country. Maybe slightly difficult, because there it was more than real estate. I mean, that is all that I want to say. It was change in regulation, and there was some US-China problem, and some US-China junk bond problems, and so it was more than real estate, and not just real estate.
Thank you for your feedback. We understand what you're trying to say. So we're not necessarily saying that the two situations are the same. We're just saying that some facets of the Evergrande crisis could pop up in India as well. Since it was a company that was involved in real estate at a greater scale, like it was the second largest real estate company in China, and due to one legislation coming into view which put a limit on debts, it went into insolvency, and that affected the Chinese economy as a whole. And there was a certain speculation that a credit crunch could arise because of that too. So we are just saying that a situation like that could arise in India, as we are seeing, because the real estate sector has a long lag of cases.
But we don't have those big real estate companies, and even in this case, the Chinese government is now trying its best to rescue this company. They are pumping in funds, and I believe they are. I don't know very. I'm not ready, but
cyclical.
You want to take it?
So what sir is actually saying is one of the feedback that I want to give you for this paper, that you have incorporated a lot of aspects, and you have tried to identify one principle from various jurisdictions, but that may not fit suitably in India. So one part is that you are presenting in one jurisdiction, this is the which comes from, which you will consider. But I find that you might not have seamlessly found a way how this can be referred to. That was my observation in this situation.
Thank you for your feedback. So we understand that legal transplantation has its own nitty-gritties, like transplanting a law of a different nation into a nation such as India would involve its own intricacies. So that is going to be an issue. We are just here to make an attempt to provide a model that would work.
So while I was reading your paper, there is one solution that you also mentioned, that the real estate company can take the money from the home buyer and invest in certain
Yes.
investments. Now, if the real estate company does that, wouldn't it be violating SEBI norms? Because then it has to be registered as an investment advisory under SEBI. If it takes the money of a home buyer and makes its own investments, now how do you address
Ma'am,
that?
so basically that investments are not for the company to use in the future. What I meant with that is that investments, like we see that the project takes 5 years, it takes 6 years. So we see that there's a time value element and an inflation which depreciates the value of the advances. So what we are saying is that we want to tackle those that inflation, and we are not essentially saying that an infrastructure company or a real estate company should become an investment company. What we are proposing is that it may not have investments directly as an investment company. It can have another outsourced company or anything. But the basic underlying issue is that we don't want the wealth to be eroded just by them keeping that money in some normal bank account which is meant to be used for procurement of raw material. We want that even the company should have the benefit, and by this you also reduce the chances of them incurring extra cost and facing inflation which creates adversity for them. Yes, thank you, sir.
Thank you so much, sir.
Chartered accountant and is also a research associate at IBPI.
And IBPI for this opportunity. I, Ajanta Gupta, with my co-author Ritesh Kavadia ji,
is here for the here to present the paper Insolvency of a Public Listed Company. Insolvency. What is insolvency? Let's take a brief view. Insolvency is a distressed position of a person who is seeking to reshape the reshape treatment under the specialized norms, getting out of way by the normal norms. So what the insolvency laws do, it set the priorities according to the, based upon the risk-bearing contractual agreements entered to the pre-insolvency. What happened? We need to understand which stakeholders we have to cater under the state of insolvency. Because it is in state of insolvency, in normal days, equity runs the board, equity runs the company. But under the Insolvency and Bankruptcy Board of it, under the Insolvency and Bankruptcy Code in India, we have creditors in control regime. So creditors now becomes the board, and equity takes the holdbacks the seat, takes the back seat. Positioning the equity holding the back seats raises a serious concern when the company is a public listed company. So when the public is a public listed companies wherein the stakeholders have the retail investors. And these retail investors are through the listing and the trading of securities on the stock exchange, and it provides an interactive platform for these retail investors. So when the company and these public listed companies entered the Insolvency and Bankruptcy Code, we mandate the code mandates the IRP or the RP to comply with all the applicable laws. It includes the SEBI regulations as well. So he has to do all the compliances with regard to the public listed companies. Let's take a brief view. What are the compliances that the IRP has to follow with regard to the public listed companies? During the process, when the companies enter into admission, so he has to inform the stock exchange, BSE or NSE, wherever it is registered, about the admission, default, then the public announcement, list of the creditors he has to informed, and the appointment of the RP as well as in case if there is a replacement, if any. He also have to inform about the notices to the COC. There are the certain compliances with regard to the reporting. He has to provide the audited annual financial reports, quarterly reports, and shareholding patterns, etc. He has to do all the SEBI compliances. With regard to the resolution plan, RP also needs to disclose about the summary of the resolution plans and number of the resolutions plan submitted, and filing of the approved resolution plan before the tribunal. Post approval or rejection also, RP has to do the compliances, like informing about the approval of the resolution plan with the certain details it has been provided in the SEBI regulations. Having seen what is unique about the public listed companies, that are the add-on compliances by the RP, in our paper we have tried to get the trends of the resolved public listed companies under the code in terms of market cap, PAT, employment, etc. Further, we have discussed about listing and trading of shares during the CRP. Then we have discussed about this continued listing of trading of shares under the liquidation process. Later on, we have also touched upon the SEBI consultation paper issued in 2022 regarding the mandatory offer of the public shareholding to the tune of 25% in the new management. And then only that the delisting exemption will be available as per the consultation paper. We have seen the SEBI and IBC laws, international practices wherever we can find it, and the opinion in the ILC reports or the consultation papers. Further, for the database, we have used the CMI database, MCA master records, and the IBBI published data. Just a minute. So, as per the IBBI published data, as on June 2022, there are 517 companies which has been resolved. So in that, 91 companies were the public listed company. You can see here in the first pie. And out of the 91 public listed companies, there were 49 companies which were resolved as listed companies, and 42 companies were delisted. They opted for the delisted, and so they were also resolved. So it's not that because they were delisted, they are not resolved. They were resolved. But IBBI listing status of the listed companies with regard to the 49 companies were maintained. Thereafter, we have studied the market cap of these listed companies. The 49 public listed companies today, the market cap is in December 2022 is around 63,000 crore. So IBB, under the IBC framework, 49 public listed companies which have been resolved today stand for the market cap of around 63,000 which has been resolved. Further, we will further analyze it pre and post CRP market cap to understand it where it was standing and after the resolution where it has gone. So during the CRP, you can see the ICD date here. The market cap for these 49 companies in totality was lying around 4,500 crores, and post resolution it has been doubled. In resolution it has been doubled around 8,000 crore, and gradually it was increased to 65,000 crore today. So year by year it is increasing. So there is an outlier.
Sorry, previous, what's the date? What is the?
It is year wise, sir. And then 51, then 62. It is increasing. Then that is a resolution period. It is after the resolution, one period of resolution, then the second period of resolution.
So it has not been delisted.
No, these are the 49 companies which are continue listed. We have studied the data. Continue listed of the companies. 49 listed companies.
After resolution and approval, how much time have you given, let's say, resolution 1, 2, 3, 1 year, 2 year, what's the difference?
Yearly, sir, 1 year. So I have seen that in the 2017, the company was under the, entered into the CRP process. So you will find it under the ICD date. So insolvency commenced soya. So outlier, after excluding it, these companies, again, we can see there is an increasing trend. So today, Ruchi Soya is standing with around 40,000 crores, which after excluding that, these companies are also increasing. The companies, resolved 49 public listed companies are also, market cap is increasing. So I hope this is clear.
Yeah, sure. Please continue.
Then we have studied the PAT, profit after the taxes. We have seen that like during the CRP, it was like minus 29,000 crores. It continues, and resolution it was increasing year by year, and post resolution now we stand for like around 3,000 crore with the positive PAT for these companies. 49 resolved companies under the IBC. Employment generated. It is not pre and CRP, it is total employment of these 49 companies which have been entered. So today 97,000, I say around 1 lakh employment has been, is being served by these resolved public listed companies under the IBC. After seeing the trends, we have discussed about the listing of shares during the CRP. So we have waived the benefits and the challenges. What are the benefits? Because there is market speculations and the violent fluctuations, it have been talked like whether the listing of the trading of shares during the CRP continued. We have discussed in the paper about the benefits and the challenges. Just a minute, please. From the point of view from the CD, the benefits is that the new management can, if it is continue listing, the new management can get the FPOs, and further this continued listing helps in the preserve the value of the company, and it gives an alternative for the restructuring for the new management also, whether they are comfortable in continue listing or delisting. If you delist it, they won't be able to continue listing and have the benefits of the listing. From the investor's point of view also, it provides an exit mechanism to the investors. They can sell it, they can book the capital loss, because the company, they don't trust, they don't want to be in to be involved in the company, so it provides an exit mechanism. And challenges, of course, there are added compliances for the RP and market fluctuations, insider trading, but weighing with the benefits appears to be more post-resolution having the listing companies, as we have seen that how the market cap is increasing of these listed companies and the employment has been generated by these companies. International practice have been seen in the UK, US, and Singapore, Hong Kong. They provide that listing status of the companies should be continued. That's what we have right now in the Insolvency and Bankruptcy Code. We do not bar the listing status of the company right now. Going further, okay, it's the company status, listing status should be continued. Whether the trading of the shares during this CRP should be continued, then SEBI in 2018 floated the discussion paper and talked about the risk-reward trade-off. I think the time is very short. How much minutes left? Okay. And ILC also said that it should not be restricted because it provides the price discovery mechanism, the going concern status. International practice, US, UK allowed it, but RP has to do the compliances. They may suspend it if the compliances are not done. In US, if they are not being in New York or NASDAQ because of the strict compliances, they are being traded on the pink sheets or OTC platform. I would like to explain the pink sheet because of the short of time. I'm moving further. So it provides the exit mechanism trading to the minority shareholders, preserving the value of the company, and additional information of the company is also provided to the if there is being trading of the shares, because RP has to do all the compliances. So all the investors are getting the correct information about the company. Continue trading shares of during the liquidation process. We have studied Companies Act, UK, Australia, Singapore, SEBI. Everywhere when the company is being wind up, it is considered as it's a death of the company, and they are being prohibited unless the court allows in certain circumstances for the particular thing, but it is being prohibited. So since in the IBC, nothing has been talked about that trading and the listing of the shares during the liquidation process. What we have seen that the SEBI is delisting the companies once it entered into the liquidation process, but it is not being uniformly followed. It can be date of liquidation, it can be after 1 month or 2 months of the liquidation. So there has to be one explicit provision under the code or the SEBI regulations that once the company enters the liquidation, the company should be delisted to have the, so nobody can misuse it, because there is no scope for the revival of the company under the liquidation. It should be stopped. Now we have discussed about the SEBI consultation paper. You must be aware about that SEBI asked in this paper to protect the interest of the stakeholders, that 25% of the percentage should be given to the existing shareholders, and then only it will be permitted to delisting. BLRCs talked about that. Enterprise value of the CD may be wiped out, and the existing shareholders may lose control and they may get nothing. Unilateral legislative guide also know that the shareholders may not get anything under the insolvency laws because they are the risk bearers. So right now we have a provision that the 5% of the public shareholding should be maintained, as per the Ministry of Finance in June 2022 has mandatory to issue the 5% to the public shareholdings. If we follow the delisting process, there is a reverse mechanism, book building mechanism, which do not require in the IBC, because we have section 53 already, the priorities are being set. And what you will get due to the liquidation value has already been considered. The having the reverse book building process won't serve any purpose. And if you don't give the delisting options to the RAs, new resolution applicants, it restricts the restructuring actually. Because we have seen that 42 companies being delisted have been restructured. They are providing GDP to the economy and the employment as well. So we should be concerned about restructuring, not the form and manner of the restructuring, that how it has been resolved. Then further, the IBBI, the legislation which has been passed by the Parliament, also says that in explanation to the section 30 subsection 2, any approval of the shareholders, if required, will be deemed approved. And there will be no contravention of any law in any law if there is any shareholders consent is required. So for all this restructuring process, shareholders approval is deemed considered. Creating a new rights to the extent of 25% will disturb the waterfall mechanism under the IBC. Why the new rights have been creating for the public shareholders, why not for the operational creditors of the governments, which may increase in further, as we have seen that the market cap of these companies is increasing year after year. So if you create such rights giving minimum of 25%, actually disturbing the waterfall mechanism under the code. And there are another repercussions, like non-implementation of the plan. If the SEBI consultation paper says that the public will contribute towards the 25%. If they are contributing, and in case the plan is not implementing, will you return the money to the shareholders? What will happen? If RA is not doing it, we'll take an action. IBB under the code, the action is being taken by the RA. What will be the stand of these public shareholdings who have invested 25%? So that they will lose more instead of gaining anything. And I want to share one thing also. In Singapore and Hong Kong, there is like some listed status of the company has a value, which says that it should be provided, it has a value. So what the court has given that they have provided the nominal value to the existing shareholders to the tune of 5%, say. In the one of the judgment, there is 5%. That is aligned with our present situation, that is, which is providing 5% to the public shareholders as per the Ministry of Finance notification. So, providing the 5% to the public shareholders.
Mindful of the time, could you just conclude in just 1 minute?
So key findings that after seeing that 49 companies, it is contributing towards the market and the economy, and listing that the trading should be continued during the CRP, and explicit provision should be there under the liquidation, and monitoring public shareholding, which is standing right now 5%, wherein we are not taking anything from the public shareholders, and providing 5% should be maintained. And yes, ticker should be added to the SEBI the stock code to aware the people that this company is under the insolvency, which is being done under the US insolvency code. Q ticker is added to the code to make that aware that this stock is under the insolvency. MCA do it. MCA on its record provided it is under the insolvency or not, but under this stock exchange it has not been provided whether the company is under the insolvency or not. So for the tier 1 and tier 2 and tier 2 cities where the information is not adequately available, the ticker should be added to the stock code to aware the public at large that these companies are in the insolvency and deal with these companies according to your commercial risk and reward takeoff. Thank you.
Because we see that minority shareholders or retail investors, they don't have as much resources as the promoters have to link their shares. So how would these rights work when you allow trading in CIRP? And my second question is, the merger code talks about creeping acquisitions. So now if a company makes creeping acquisition because of the low value of shares during a CIRP, and then would the company go for liquidation, and the new company who has the new board would have to face the face the liquidation, or can the new company take over the company which is going under CIRP? And if it's the latter, then how is it how do we justify a legal system letting another company take over a company during the CIRP?
As far as I can understand your question, you are talking about the minority shareholders to protect the minority shareholders to sell their shares during the insolvency, right?
Yes, I'm basically emphasizing about the tag along or drag along rights in the minority shareholders.
In insolvency, we have section 53. It is not normal mergers and acquisitions. That's why I started my presentation that because this is a distressed company, and in distressed company, the specialized laws will be followed. It is out of the way of the normal laws. So when you are shareholder, you have taken the risk to as a capital contribution, and you adopted that all the other liabilities which are secured, financial operations, government dues will be served. After that, because I am the shareholder, then I will take, if anything is remaining, I will get it. So shareholders, and trading will allow the minority shareholders to get the whatever the price is available and book the capital loss even. If you stop the trading, it will be nothing there. And in the liquidation, the moment it enters in the liquidation, you will find the companies at the zero value. So these minority shareholders who can actually sell the their shares during the CRP, and whatever the risk reward they want to take it, they can go further. So they provide the opportunity and exit mechanism to the shareholders. And in USA there is a speculative trading also during the insolvency. Whoso want to take the risk in the insolvency cases, like insolvency companies, so they invest into the companies and take the risk. We do have the investors like that. So the person who wants to take the risk will buy the shareholders, and minorities will be get out of it. and book the capital loss at the same time. Thank you.
I have a question.
Yes, ma'am.
So, is it enough to just look at a graph and say that since the market cap is going up, you conclude that the listing has to be continued?
Very rightly asked question, ma'am. Market cap is just to show the trend. What is the trend of the companies right now? It is not the justification for the listing and the delisting of the company. Listing and delisting has to be based on the laws, benefits and the challenges. Even if the market cap is going negative this year and it may increase next year, still it has a potential to go up and down. Right now the records are saying positively. It may be negative in the next year, ma'am. So it doesn't mean that we should make the laws based upon all this data. Data shows that it is going good. But laws should be based on the benefits, challenges, all the pro and cons. So I would have shown this before and data after that. That will change your perception that these are the laws and these are the trends.
So the reasons for that also should be examined.
For market cap increasing. Yeah, I understand, ma'am. It's just an interesting topic. We can write a book even on it or working paper. Since the 10,000 was my limit, so I've written a research paper. Thank you so much.
In the sense, it's a positive indication that market is forgiving for insolvent companies. Once restructured, market is again put in trust on new management. Market can be an indicator for that fact.
Let's say what happens if the company is unlisted?
Huh.
Does the total assets of the company grow or the equity of the company grows?
That needs a detailed study. We have to go to the balance sheets and all. Then we have to study what is the enterprise value of that company. Unlisted companies, we have 126 companies which are unlisted and resolved. That's another big study. We can go further if successful. It's not like public listed companies are only companies. These unlisted companies has a great potential towards the GDP and employment and the contribution to the economy. And it needs a detailed study. And I hope I can do that also further. Thank you.
Excuse me, ma'am. I had a quick question.
Yeah.
So if we allow the trading of the shares of the company undergoing resolution, how do we ensure that the applicants barred under Section 29A do not indirectly acquire control through the stock market?
Internet.
But so many shares should be available for sale.
Basically, the 29A is for getting the equity after resolution. Any equity held before that, before resolution does not, because in any case 29A part people are holding the equity. Most of the equity is with the promoters already. So
No,
that is not a bar.
No,
So
actually-
whatever equity they are trading, that is pre-resolution equity.
No, that is true, but what ma'am is proposing is that during the resolution, if the company continues to be listed.
If company continues listing after resolution, the resolution plan entails.
No, actually, the thing is, this is a creditor and control moment. So the voting on the acquiring through the IPC is actually by the creditors. So they would not have a say in the resolution.
Right, I understand you want to say the resolution.
Basically, your question is, once the company is continued trading, after resolution, it maintains the listing status, but the share structure might change because of resolution, and whatever is there, even the 29A bar people can get something out of resolution. They don't decide on that, they cannot take over the company, but they can, even related party financial creditors get some use during resolution. So they don't have deciding power, but they can get something out of this resolution.
Okay, fair enough.
They cannot take over because they have a custom takeover powers.
Right, that is
How
also
can they
true.
take over so much 51%?
No, even despite working for in the insolvency domain, most of us might not even have heard about this fund. But yes, it's there in the code in section 2 under section 224. And it's like if we want to compare it, there are other funds in other laws as well, and similar to that, this fund is there. But despite being there in the legislation, it's not operative yet. So undoubtedly, IBC has achieved several milestones in 6.5 years since its inception. However, there are some legislative policies that are yet to be addressed. As to my point is, why such a fallacy is there that this fund is still not audited. So accordingly, some questions turn up. Eventually, NCA released a notification in which it asked for public comments to improve the legislative part of this fund. However, it was a year back in 2021 and yet there is no operation on this fund. So accordingly, some questions turn up regarding its administration, regarding the contribution, regarding the utilizations and governance of this fund. And so this paper attempts to answer all of them. So the methodology that I have used in this paper is the theoretical analysis of the academic resources, the reports published by the regulatory bodies, legislations of foreign jurisdictions, primary data and some other internet sources. Further, there have been some personal consultations and relative comparisons in global domain. So what does this section 224 says? It has said about the contributions. There can be 4 sources of contributions. Second can be the, this is, why should the state bear the administrative cost of this fund when it is for specific persons and not general public? So with this, I'll move forward. Now, after analyzing around 16 countries, and some global comparisons by the working papers of ILO, I have somehow tried to put it in the paper what can be the possible contributions and the utilizations of this fund. So first of all, the contribution part shall be broadened to include the contributions even without the intention of withdrawal. The current legislative framework, it says that you can withdraw only if you have contributed and to the extent of the amount you have contributed in the fund. So it shall allow contributions even without the intention of withdrawal, and it shall allow withdrawals even without the contributions. Then there can be some incentives like there can be some tax benefits, there can be some relaxation in the fulfillment of legal compliance to actually improve the utility of this fund, in the sense that it incentivizes contributions. Unless it incentivizes contributions, the fund will be lacking money and the operational part as well. So the sources can be the grants and donations by the governments, that is already there. There can be voluntary contributions. Apart from that, there can be contributions in the pursuance of their CSR obligations. Now a question might put up that how can CSR play a role in this? So simply because CSR is for the social objectives, and the insolvency, the objective of the insolvency resolution is also that we cater to the interest of all the stakeholders. An employee is one of the stakeholders of the corporate debtor. And when we are securing their employments, when we are securing their debts to the company, I believe CSR obligations can be a major contribution. Then there can be some unclaimed money from the funds, and there can be disgorgements under when tribunal order, like RPs and IRPs may be ordered by the tribunal to disgorge the amounts. Penalties that are paid by IPs. Then there can be money lying in the previous funds, which were again not very much functional. And there can be donation by taxpayers, which will again require an amendment in the Income Tax Act under Section 80G and everything. Then there can be some recoup funds. So we all know that there are insolvencies in the state, and that's why the idea comes that they should give a percentage or part of their profits, or after the revival at least, to contribute to the fund as a mandatory source. Then obviously the investment income will be there, borrowings only if they are necessary, and there can be other sources as well.
What is the value of the fund now?
It's not operative yet. So now coming to withdrawals. As I have already said that the purpose of establishing a fund when a contributor can only withdraw to the extent he has contributed, he can simply save and invest at some other fund, some other schemes, and why should the state bear such costs again? So in that perspective, the utilizations also need to be modified, and there can be certain utilizations, and I have just tried to, that just attempted to mention a few, that we can provide payments to employees and expenses by contributors, and even from non-contributors, but with the prior permission of tribunal. So the idea behind making this demarcation is when they are contributing, they are actually contributing something to the fund and they will be getting the benefit of that. But if someone is not contributing, why they shall be getting benefit, that tribunal has to decide. So we leave it to the judicial wisdom. And then there can be claims of organization for social cause or national defense that may be settled via this fund. Again, the discretion of administrative authorities in such part has to come into role. And then for awareness and research purposes, for forensic audit purposes, for the expenses of the administrative authority itself, and some other utilizations. Another possible utilization can be the interim finance. So in what circumstances the interim finance can be given by this fund to the corporate debtors will be again left to the judicial discretions. Then non-contributors may also utilize the funds for paying off the employees' claims and avoidance permissions with the prior permission of adjudicating authority. Now, when we are allowing that, okay, this claim should be allowed from the fund, then there must be a check and balance, because we cannot just provide. We have to maintain a check and balance criteria, and so we were able to thought of that there shall be an income cap criterion on the employees, which employees shall be able to get their claims from the fund. So as we all know that there are some white collar employees and there are workmen, and depending on their pay, the employees have different capabilities to have a haircut. So it shall not go into the bureaucratic hassles, and it shall not only be utilized by the upper class employees or white collar employees. We believe that there shall be a criteria.
But this is the board, this is the regulator, this is not the government. Government may undertake social security or the social welfare schemes, but it is not the role of the regulator. I mean, this is my view. So how do you want to argue that this could be the role of regulator, right? This could be the role of regulator, vis-a-vis, or it should be the role of the government to look for the social welfare measures?
Thank you for the question, sir. So first, we are talking about the legislative framework of the code. Since all these amendments, if they are incorporated, then these will have to go by the legislative procedure. That means the parliament will have to make amendments in the code itself. And then while, yeah.
Fund is insolvency fund which is controlled by the regulator. So we are not talking about the parliament or the government doing something. Parliament will make the law, but it is the implementation agency. Implementation agency is the regulator.
So again, the code does not provide anything about the implementation of it. The administration part is still under ambiguity. Who will actually administrate the fund? Whether the regulator, that means IBBI itself, will regulate it, or whether there shall be an other authority who shall administer the fund. For example, if we compare it with the Investor and Education Protection Funds in SEBI laws or Companies Act, there are separate authorities which manage this fund, which operate this fund, which administrate, do the administrative activities of this fund. So again, in the later part of the presentation as well, I have proposed that the administration of this fund shall be through an administrative authority which have stakeholders of both the regulator, other ministries like MC and everything. So when it comes by law, when it comes, and the administration part is done by the administrative authority, again it has to fulfill the social welfare criteria. So I hope that answers the question, sir.
So you have mentioned something about principle of exclusion which were referred from Netherlands. Yeah. So how is this maintained in Netherlands? Who manages this? Is the government or the regulator, or is it some independent organization?
So in Netherlands, if we go by this table that I have made, so there is a wage guarantee fund in Netherlands, and the administrator there is UWV. Again, it's the acronym, the full form is in their regional language, the Dutch language. but it's an administrative authority that has been set up separately for this wage guarantee fund. So again, I would have come to this part later, but there are comparison of like 15, 16 countries where we saw that, yeah.
Please be mindful of the time.
Yeah. How much time I have left? Okay. So I'll just quickly wrap it up with that these countries have different methods. So if we go by including the employees' claims, but have included a variety of things. And then in Japan, there is actually an ARC that is backed by government, which is funded by government of Japan, and that handles. It's like these are not exactly the insolvency and bankruptcy fund, but their sources and utilization are way too similar to what we have incorporated under Section 224 of IBC. So, and then if I talk about the foreign legislation, there are ILO conventions and recommendations as well, in which besides assigning privilege to the workers' claims, their claims shall be, they have said that the claim shall be guaranteed through a guarantee institution, where a payment cannot be made by the employer because of insolvency. So several jurisdictions prefer preferential or priority regimes with respect to the claims of employees instead of having any designated funds for the purpose. However, the problem associated with the limited priority system is that it is inadequate to protect the employee's compensation. And that can be addressed by implementing a combined wage priority, and this whole paper goes to Dr. Kokila Jairam and Asit Behera sir, who when I was working with them and I wrote this paper, and they have their valuable inputs. This paper have their valuable inputs, and yeah, so I would not take the credit of this whole paper.
Yeah, because you would not know about all of this.
Definitely, sir. This is just the administration part is just a procedural thing that it shall be established by whom and whom. I would say, I will not take much of your time. I'll just say that there shall be an administrative authority and not only government body or the regulator who shall manage it, because then it will have obviously more inputs and better utilization when it will have relevant expert members. And if I end the presentation is that, so I believe this concept has remained dormant for years now. We have Companies Liquidation Fund in Companies Act 1956, then is Companies Act 2013, yet there are nothing much on paper or in reality. So I believe why this fund having so much potential, that too when we, in this era we are talking a lot about the operational creditors, that they are the most hampered category in the whole insolvency resolution process. This fund has great potential to cater to their needs. And then this paper lays the ground framework for legislators to make the IBF more operative. So any questions on the floor? Thank you.
It's totally society based. So if this comes into effect, then it is almost like a corporate shield. So how would that do justice to a CSR law under Companies Act? So again, give the purpose of it.
I am unable to get your questions on it.
So the 11 categories that's what I was talking about.
So there is a clause in the Schedule 7 in which they recognize contribution to Prime Minister National Relief Fund that was made during the COVID time, and it was considered as a fulfillment of the CSR obligation, and that only contribution to this fund, which is for a social purpose as well, because we consider the rehabilitation of companies a social purpose, considering the how many stakeholders from the society are involved in a company. When a company goes down, it's not just the company and promoters who are going down, it's the society, it's the employment, it's the public who are getting affected by that company. Most of them, the employees, I believe. And that's why you will see that in most of the foreign regimes as well, there is so much focus on how to protect the employees in this whole insolvency domain that they have made separate priority regimes as well as the wage guarantee funds to protect their use.
Manshi. So the next presentation will be by Mr. Shashank Sharma.
And everyone. So my today topic of discussion is asset restructuring companies in India. Is it still a relevant resolution channel post IBC era? ARCs or bad banks recently introduced in India. So the government is infusing, so long story short is, public sector banks were in distress from a long period of time, and government is very serious about the resolution plan. But the government is also introducing capital for the recapitalization of banks, and these banks are investing into ARCs for the resolution plan. The idea behind it was that to let banks concentrate on their core business while ARC do the resolution job. But the issue is with the introduction of bad banks, PSBs are also investing their capital investment in the form of loan and borrowings and expert workforce. Most of the expert workforce and the board members of the ARCs in bad banks is the members of public sector banks. So you get an idea about how serious the government is. Plus, we have to decide how much hand-holding is too much hand-holding. I've used binary logistic regression for ARC's linear regression, and I've used HP filter for long-term analysis of the data. So let's talk about IBC 2016 and its efficacy. So red part is recovery rate, and green part is time taken for resolution. So as you are seeing that the recovery rate is declining. The dotted line is actual data. The straight line is the logarithmic trend of this data. And the time taken for resolution is increasing. Month on month you can see. This is the presentation of the actual data. I've run a regression on this. These are result of the regression. I've coded the time delay as per the section 12 of IBC, that maximum 330 days is the threshold. Then any delay after 330 days is coded as 1, and before 330 days coded as 0. So
have you taken into reckoning the COVID period and the remiss allowed by Honorable Supreme Court, 2 years remission?
This research is basically data driven. As per the data published by the IBBI, I have included all the data from August 2017 to June 2022, month on month frequency.
But you have to also analyze the reasons.
Yes.
The reason was COVID.
Yes.
2 years, there was hardly any work being done.
Yes, that may be included in another study, I suppose. I've just basically experts are in the favor of IBC. They say that IBC is the future, but they vetted on IBC, but they also think that some ARC need to be there as a support system for the IBC. And mostly majority of the experts believe that proactive regulatory involvement may improve ARC's performance in the future. And about bad banks, most 36% were not able to answer the question because they believe that it's an evolutionary process and we will see the results in coming years. Compared to all these countries, green line, bold line is resolution rate, time. You can see India, Malaysia, and Philippines, and Thailand are able to reduce their resolution time to a great extent. So I have further studied these countries who are able to reduce the timeline. So let me summarize this. So Philippines, Malaysia, and Thailand were using some very particular methods. I will discuss the case of Malaysia and Philippines. Philippines need a highlight in this because recently in 2021 they have introduced 5 bad banks, and they have a barcode system in which they can trace the stressed asset. When the stressed asset is acquired by the bank, and not acquired, classified by the bank as a stressed asset, and when it is resolved. So they keep a track of the date of the stressed asset. So let me summarize. So IBC as a channel of resolution has reached a milestone. I mean, it's better than other channel of resolution, but it failed to exceed its own expectations. So it's a milestone towards a benchmark. ARCs may stay relevant, as I said. So we have two options left. Either we can reduce the time delay, or we can reduce the rising default. And one other notion was that multiple resolution channels are better for workload sharing, but there must be clear division of work. Which resolution channel would do what to eliminate the confusion. Recent case has been the ARCs has been filing resolution application with IBC. So bad bank may evolve in India, provide proactive support and continued commitments of the government, which is there. So I've recommended some key recommendations. First is transparency. So transparency is required in disclosure practices of ARCs related to the age of the stressed asset. And competition amongst ARCs is required, and informed distribution of asset under management is also required between the ARCs. That will discourage moral hazard of the ARCs between them and their hand-holding hoops for the government. A blockchain-based technology must be introduced to track the life cycle of the stressed assets in ARCs. KPI disclosures is also very useful in the other emerging economies. We can explore this field also. Regulatory control and support of the government related to establishment and overseeing agency other than RBI. I mean, IBBI and RBI can collaborate and make an overseeing agency also. And international experience learning curve we can look upon, like we can sign MOUs between the other bad banks and gain a technical know-how that how they are resolving and what we can do better. So these are additional slides. That's all from me.
You have to first explain the concept of ARC, what their balance sheets to look after. Now suppose a bank has got, let's say, out of 100, let's say it's got 10 bad debts. So those 10 bad debts will pull down the profits of the company and present a negative picture about the bank's balance sheet. So what they do is, instead of those 10 bad debts, they find an ARC, they offload those bad debts to the ARC. That ARC in return gives them, say, 15% of the amount of bad debt. Let's say the amount of bad debt was, say, 1,000 crores. So they will give them about 150 crores up front. And remaining 850 crores, they will give in the form of SRs, security receipts. Those security receipts perhaps never go back to the bank, but the balance sheet becomes clear and the amount of money it shows as SR. So I'm not able to understand this concept.
Sir,
You're calling ARC also as bad banks?
Yes, yes. First of all, answering the first question, why do bank needs an ARC? As you rightly said, the SBI has its own agency in place. Yes, yes. That's because, sir, that agency, SBI is a big bank. Every bank has not has such an efficient team working for them. So ARC is a bunch of expert people who deal with resolution of stressed asset. And banking core business is banking, not resolution of stressed assets. So they need people. Yeah, even you rightly said, if we able to train banking professionals in resolution mechanism, I mean their functional heads, and we able to train them, then the need of ARC may not be as useful.
There is some accounting concept involved. That is why they are needed. It is not because of resolution of stress. All bankers know how to resolve stresses. They are all under the RBI.
Huge write-offs year on year in the balance sheet of bad banks. These total security receipts, the total is about 108,000 crores.
So usually it is like so saying basically just the debt is assigned, so then it's anyways
bonus in their books, right? So we usually assign the debt, which is why in NCLT you will see the change in the applicant name.
Yeah.
Because over there, ARC is slowly taken over from all the banks.
They assign the debt.
Yeah.
But once you assign the debt, then how does the balance sheet change?
No, because they got balance sheet on the bank side.
On the bank side.
Because they've got their 15-85 ratio means
15% they've got, but 85% chances they will never get it.
But anyway, their value, they've already written off the back. They've already written it off. It's already transferred to the stressed asset team, So it's already the value in the is anyways. It's already zero. It's already written off.
Yes, and the banks believe that something is better than nothing. They are already facing haircuts over these stressed assets.
Not very clear. Why do you mean to say that banks write off bad debts? So if there are bad debts, then they pull down the profits of the bank. I don't think so. There is some other formula which they are using. Only a banker can tell us.
I did have one question. In your data, I think like ma'am was mentioning, your ARC data was till 2020, but your IBC data was till 2022.
Yes, yes. So
then there's a mismatch there.
I've tried to include as much data as I can, and you rightly said the COVID period should be excluded. We can write another section, the impact of COVID on these channel of resolutions.
Okay, so thank you.